All right, so I've been thinking about this a lot over lunch because we all got turned around pretty quickly, and that's on me. Here's what I think we should do. Mr. Fletcher wanted to voir dire the witness on his where he was at, and I was thinking that might be a good idea to do this so we can put on the record what the answers are that we're dealing with. So if you want to do that, he could answer freely outside the presence of the jury, and then I could get a little bit more information about the interplay between the standard of care and if you don't want to do that, that's fine. I'm just offering that to the defense as an option at this moment. Do you wish to do that outside the presence of the jury, or do you wish for me just to make a ruling?
Give me a second.
Yes, yeah, I'm aware that I'm catching you off guard. I'm trying to give you a minute. And I am sorry for chirping at you.
Oh, yeah, I deserve it.
Well,
Should have shut my mouth. Yeah, Your Honor, I do have some questions.
all right, well then, the floor is yours. Now listen, for this part of the testimony, the jury is not here. You may answer it freely as if you normally would, because that's what I'm trying to judge.
Sir.
All right, floor is yours.
Thank you, Your Honor. Mr. Napier, just for the record, my name is Clinton Fletcher. I'm one of the attorneys at Gray Russ, and I have the distinct pleasure of being a mentee of Mr. Moffitt here, who you know intimately. My purpose here is not to get sideways with you, just to arrive at some common questions or issues that we can get to the bottom of it. You're here obviously to testify about industry standards, correct?
Yes,
Okay, and those industry standards are based upon the regulations, the law, correct?
they are adopted by the industry for compliance purposes because the industry has to comply with them, but then they develop those compliance methodologies and techniques, and collectively, they're the industry standard.
Okay, but those industry standards are born out of the regulations, right?
I don't disagree with that, but I'm not, I think that it's important to explain to you that I'm not saying that it's a violation of the regulation. I understand that the industry, or even my knowledge of the industry standards, could be questioned as to whether or not that's the applicable law. I'm not testifying to violations of the law, just this is the way the industry treats the standards of care and how they work to comply with it.
Okay, but without the regulations, the industry would not know how to comport, correct?
I would agree with that.
Okay, so then getting back to my question, everything comes out of the regulations for the quote, end quote, industry to follow,
The
correct?
genesis of it, but not everything. No, sir.
Okay,
So I can give you examples, but not.
I don't
every-
need an example.
Okay.
All right, now in terms of these industry standards aren't written, are they?
No, that's why I'm proffered here to, based on my experience, and the only remedy you have on my experience is your cross-examination.
Exactly.
Right.
And your opinions here today, these are opinions that you've not published these opinions, right?
No, I've written those standards or established those standards for companies that I've worked with and had to comply with those standards. But I have provided references to those standards throughout, but no one place. Is there one place that you get those standards? That's why you have to have an expert with experience to be able to tell you what they are.
And in terms of, but again, to answer my question, you have not published any book, Industry Standards by Mike Napier, right?
Absolutely have not published any standards, but I have written and established the standards of care for trucking companies and evaluated thousands of those policies and procedures and those standards of care in the industry.
Okay, and those standards that you provided to your clients or other trucking companies, were those ever put peer reviewed by any other experts?
No, as you should know that I'm not required to be peer reviewed under Daubert, that they're not subject to Daubert factors for peer review, and so therefore they are not peer reviewed.
Okay, and has there been any other peer-reviewed journal that has said that we have tested your opinions and have determined that they're accurate?
With the specificity of your question, I know of many studies that have peer reviewed, but I'm not basing any of my opinions necessarily on those studies. I'm just telling you, these are the industry standards of care and the way that the industry reacts and complies reasonably with the safety standards.
Okay, and whether the industry complies reasonably, they have to look to the regulation, right?
In part, not totally, but yes, the genesis of the standards of care are the regulatory standards, so the industry has to know how to comply with it. So as an expert, I teach how do you comply with those standards. Now, my compliance methodology for the industry, as I'm testifying, may be questioned by the law, but this is how the industry, in fact, understands it, complies with it, and establishes the techniques for safety.
All right. These regulations, they're written, right?
They are, by the
All right.
government,
And the
yes.
judge is going to be able to state what those regulations are at the end of the case, right?
Yes, but yes,
Okay. And whether the industry is supposed to interpret those regulations, that the regulation actually says what it says, right?
the industry, it says what it says, but the industry has to understand what it says in order to comply with it, and then establish those methodologies for compliance and techniques for safety.
Okay. And you would agree with me that the regulations are pretty detail oriented, right?
They are,
All right. They lay out page, line, and verse what what a motor carrier is supposed to do, right?
for enforcement purposes, yes.
And also for compliance purposes.
Yes, for compliance, but
Okay.
they are enforcement standards,
Yeah.
and we use them for compliance.
And the regulations aren't just a one page that says, please see industry standards, right?
No, it doesn't say that. The FMCSA, the governing body, says that to the industry, use the industry stakeholders and these standards to comply with safety techniques.
Yes, and they asked the industry to follow the motor carrier safety regulations, right?
As well as the industry standards and stakeholders, yes.
Yeah. Is there a specific clause that says follow the industry standards?
Well, it's considered, it's under 389, they say with specificity that they consider the industry standards.
Okay, and the statute that the judge will read at the end of this trial, it will say that you are to follow the industry standards.
That's not the word that I'm using. I'm using that under 389, under the rulemaking section of the regulations, it states with specificity that the regulations consider the industry standards.
And that is the exact quote of the statute.
Yeah, I got a copy of it right here. I'm prepared to show it to you.
All right, in terms of you evaluating a case, what is your theory and methodology that you follow to determine if a company, such as Transcontinental, followed the industry standards?
Well, I don't have a theory. I follow a specific methodology to determine whether or not the relevant standards of care were breached.
Okay.
And so,
Sorry, I didn't mean to cut you off.
no, that's okay. If that's enough, then I can stop. But I was going to say, then I go through the evidence that I have, decide whether or not that's relevant, and then whether or not those standards of care were applicable to our circumstance, and whether or not they were breached.
Okay, and then you would also compare that facts and evidence to what is the actual language of the regulation, right?
I provide the citation of the language, but I would tell you that my testimony will be that it's a violation of the industry standards of care, which includes the understanding by the industry of those regulations.
So it's the industry standard that looks to the regulations to develop what is that standard, right?
In part, that is true for certain specific parts, but as I mentioned earlier to the jury, not everything is codified in the regulations. For example, the methodology, the speeds, the space requirements, how do you do it? Those come from the industry standards of care. And so knowing what the genesis of the standards are, the regulatory standards that I have to comply with, I have to know what the methodology is for compliance, those management controls and systems, as well as the techniques for safety. I'm testifying cumulatively on the industry standards as I have in the state of Georgia since I've been doing this. Ron?
Nope, I'm not done yet, Charles, hold on. Your Honor, if he's gonna talk about some industry standards, that's whether it's written or his opinion as to what a company is supposed to do in between the lines of any vague regulation, I think it'd be okay. But if he's going to cite to any violation of a regulation, those are conclusions, and he's reciting the law.
Okay. All right. Anything else?
Can I speak, Your Honor?
Yes. I mean, if you're finished, Mr. Fletcher.
I reserve some time if he brings something up I need to address.
Sure. Fair enough.
Your Honor, I think you've already ruled that he can't testify that any specific act or omission of the defendants in this case, whether that was a violation of the federal regs. We've already agreed that. Now, I will point out that there was a deadline for Daubert, and that was several years ago, and there was no Daubert motion filed against Mr. Napier. I also asked this question in my direct examination. I tendered Mr. Napier as an expert in the field of regulatory and industry standards of care in commercial motor vehicle operations and safety. There was no objection by the defendant. So, we're ready to proceed under the standards of care. He's going to talk about the standards of care, which they've already agreed to. There was no objection about that. And we would like to clarify what that means with some specific examples, just so we don't run afoul of the court's ruling. But we would like to get going again.
Okay.
Thank you.
All right. Does anybody else need any more access to the record?
I do, Your Honor.
Go ahead.
Your Honor, when he qualified Mr. Napier, he was qualifying him as an expert in industry standards. He wasn't qualifying him as an expert as to what the regulations say and how they should be applied to our clients or the facts of the case. And that's what he's done in a couple of lines of his testimony, Your Honor.
Okay. All right. Thank you. All right. Anybody, anything else before I make the decision that, as always, is going to leave everybody a little happy and everybody a little mad?
No, Your Honor.
Okay.
No, Your Honor.
All right. Here's where I'm at on this. So I do find, I did a lot of research over lunch. I do find that the federal motor carrier regulations, I did practice that saying that over lunch, are not the standard of care themselves. We're all in agreement on that. But they are intertwined with the standard of care, and I don't see how we could possibly allow a thorough and sifting cross with, and frankly, the standard of his opinions without touching on them. And I repeat, touching on them.
Sure.
The previous ruling does stand. You're not to opine as to whether something was or was not a violation of the FMCR. But the standard of care is fine, and then you're going to get cross-examined fully by two expert attorneys. I'm going to give the expert charge here. So before the jury resumes, so that they hear me say one more time this is just the pattern charge on experts. That way they understand that anything they hear is their decision to take in or not. And again, I had several cases, but I just grabbed these two because I referenced this one before lunch. I just thought if I referenced a case, I should at least put on the record what it is. I referenced the DUI case where the officers are allowed to testify that somebody was in fact under the influence to the extent it made them less safe to drive. And that is Lewis v. State, 214 Georgia App 830, 1994. Again, I know it's not a criminal case, but I referenced it, so now at least we have a citation on the record. And then accordingly, this is not exactly on point, but it's pretty close. Peterson v. Reeves, 315 Georgia App 370. The facts of the case are not analogous to this situation, but the ruling on how an expert may opine was what resonated with me, which is it says that the expert may opine that to a reasonable degree of medical certainty they did or did not, I'm paraphrasing, did or did not comply with the standard of care. And then it goes on to talk about where the standard of care came from, which is from the statutes. So that was the only point of that one, is that those things are intertwined no matter where you go and what we're doing. Again, those two cases are not controlling. They just were what I had and what I'd referenced. All right. So here's your testimony. You ready? So you may testify about the regulations as they are to the standard of care. but you're not to tie, but any conclusions must be tied only to the standard of care and not to the regulations. Do you
May I
understand?
ask a question?
Yes,
So may I say that it's a violation of the standards of care?
yes,
Okay, that's all I wanted to make sure I understood.
but do not in any way whatsoever
I will
reference
not,
that
never
too.
do.
But I think that having the expert talk about the regulations would be helpful to the jury because this is not information they know. And I will, of course, charge them that this is it. So, all right. So I know that's not what either of y'all wanted, but that's what I got. So any questions?
I have a question, Judge. He can comment about the regs. He can talk about his interpretation of what they mean. He just can't apply the defendant's conduct to the regs and say there was a
That's
violation.
exactly correct.
Okay.
Right.
One other question.
Yes.
Well, can he comment about an interpretation of a violation that doesn't involve the parties in this case?
No.
Just for clarification.
I'd rather he limit that because that's what got
That's
me.
the line.
Yeah, that's where I got really nervous when I was sitting here before. So be
That's
very
the line.
careful.
I'm just,
Yeah, be very careful with your examples and your extrapolations is what I'm saying.
Yeah,
They got it.
I'm not sure I understood.
If you start saying other examples that we may stop you if
can't use a
Related to this
hypothetical.
case, you mean?
outside of this case.
Oh, okay, I didn't know
You,
that.
you've done that just a little bit, and I'm just saying, we're already walking a tightrope here. Let's just
Okay,
walk
I
it.
didn't understand that.
Yeah, well, I hadn't said it before this moment.
Your Honor, there's already been testimony that he stated that our clients violated a reg. So we've moved to strike that testimony.
I will, I'm not going to strike it, but I am going to give the expert charge, and I'm going to add to the expert charge to the jury that they and only they will be making a decision as to whether or not anyone violated any regulations, and they are not to take any testimony as such as there. But I'm gonna leave it in the record, and I'm gonna give that clarifying instruction to them that the testimony of experts may be accepted. Well, I'm just going to do the language here. The testimony of any expert, like that of all witnesses, is given only such weight and credit as you think it is properly entitled to receive. So, and then add to them that they are not bound by anything. They're not bound by his opinions. So, any more than they're bound by your experts. So,
Your Honor, just respectfully, we'll just object to that curative language.
that's fair enough. So, okay. Hey, Clint, you ready? Got a power nap in, you're good. Sometimes we have to wake Clint up. Asleep. All right, everybody may be seated. All right, members of the jury, thank you for your patience. What you saw before lunch was frankly on me. They were looking for some clear instructions from me as to the rules of engagement with this witness. They didn't get those. We took the lunch break, figured that out. And so we should be okay moving forward. I'm going to give you a quick charge on experts. And so if you'll please listen very carefully to the instructions I'm about to give you. Members of the jury, Georgia law permits parties to present testimony by certain witnesses who are deemed termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. I will determine if a witness is qualified under Georgia law to be considered an expert. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. And then I'm going to add one more addition to that, which is you and only you will decide if anyone has violated any regulations, and you will be given those in the charge at the end of this case. All right, you're all nodding at me, which means we're back on track. All right, defendant's objection is noted for the record and preserved. Mr. Scholl, you may continue your question.
Thank you, Your Honor. Mr. Napier, you talked a lot about industry standards. How do industry standards relate to the federal regulations?
So the industry standards are, the genesis of the industry standards are obviously governed by, at the beginning, the genesis, the beginning of those standards come from the regulations. Not all of the standards are in the regulations, and not all the regulations are clearly defined. With regards to how that works together, there are federal regulations that motor carriers are required to know and comply with. So knowing that, we have developed the management controls and systems in the industry for compliance with those regulations and the techniques used for safety. And so all of those collectively are, to borrow a term, intertwined together as what we call the Commercial Motor Vehicle Industry Safety Standards.
Okay. Do the industry standards reflect how the trucking industry adopts and applies the principles of the Federal Motor Carrier Safety
Not
Regulations?
sure that I understood. Could you restate the question again?
Sure. Do industry standards reflect how the trucking industry applies and adopts the principles of the Federal Motor Carrier Safety Regulations into their businesses?
Yes, they do.
Okay. Now, are all the opinions you're giving in this case regarding preventability and the defendants based on the industry standards of care?
They are.
Now, under industry standards of care, was Mr. Evans medically qualified to drive a commercial motor vehicle on the date of the accident?
He was not. And so you go back again to my intertwining. The content of the regulation says, number one, as we understand it, is that if you are out of control with your insulin,
Your Honor, can I approach?
You may. I'm gonna let him finish. I know you're frustrated, but I know, I respect your position. You may continue. The objection is overruled.
so again, the genesis of that circumstance is what do the regulations tell us, and then how do we comply with it? How do we teach drivers to comply with it? What is the methodology for compliance, and whether it's a violation of those industry standards for safety? And the regulations say that you're not qualified if you have out of control insulin dependent diabetic driving a vehicle. It also says that if you are an insulin dependent diabetic, you require certain exemptions that you have to go through to get that exemption in order to get your physical complied with. And so in essence, that's how they work together. We know what the regulation content says and how does the industry comply with it. They wouldn't let a driver drive that knew that he was out of control with his insulin.
Mr. Napier, can you cite to the federal regulations that deal with insulin-dependent drivers in commercial vehicles?
Yes, sir. Under 391.41 and 391.46 of the federal regulation, I'm going to provide just the content of those standards.
Oh, Mr. Napier, we're going to put that on the screen as well.
Oh, you're waiting on me. Objection?
Yes, Your Honor, may we approach again?
Sure. Terry, you're getting these up here, right? rules to let y'all try your case. So you can talk to your truck manager. Again, I respect your position very much.
So we can keep this moving, can we have a standing?
You may absolutely have a standing objection. So the defense's request for a standing objection is granted. And if you need anything else to get to the record, Mr. Fletcher, just let me know. All right. I hit the wrong button because I was thinking of 17 things. All right, there you go.
All right, and can you point out to the jury where it mentions diabetes?
39141 on the, I'm sorry, 39146 is where I'm at.
All right,
Physical qualification standards for an individual with diabetes mellitus treated with insulin for control. An individual with diabetes mellitus treated with insulin for control is physically qualified to operate a commercial motor vehicle provided the individual otherwise meets the other requirements in 341 or has an exemption or has a skill performance evaluation certificate if required. And the individual has the evaluation required by paragraph B and medical examination required by paragraph C. Now, under this is paragraph B and C. Evaluation by a treating clinician. Prior to the examination required by 39145 or the expiration of the medical examiner certificate, the individual must be evaluated by his or her treating clinician. For purposes of this section, the treating clinician means a healthcare professional who manages and prescribes insulin for the treatment of the individual with diabetes mellitus as authorized by a healthcare professional state licensing authority. Further, if you go down to now C and go to 2II, which is what I was referencing earlier, the individual is not physically qualified to operate a commercial motor vehicle. I'm sorry, it's two I's. The individual is not physically qualified on a permanent basis to operate a commercial motor vehicle if he or she either has severe, I'm sorry, I'm still reading the wrong one. It's I. The individual is not physically qualified to operate the commercial motor vehicle
could you hold on
if
just a
he or
second,
she,
so the jury can follow along?
I'm
with it?
sorry.
That's okay.
I was reading the wrong section and I apologize. The individual is not physically qualified to operate a commercial motor vehicle if he or she is not maintaining a stable insulin regimen and not properly controlling his or her diabetes mellitus. Those are the content of the regulations, and the way the industry treats that is that A, there's a methodology for supervising his physical. Was he had a proper physical? Did we look at it? Did he fill out all of his disclosures correct? And if you have a driver that's operating a vehicle with it not being controlled properly, it would be a violation of the industry standards of care to let him drive.
Have these regulations, based on your experience, have these regulations evolved over time? Say from 2000 to the present?
All right, y'all pull those off while you're going on to your next.
So the answer is yes. It's evolved from 1940 to the present. And so, but just going to the most recent time before 2018, it was almost completely banned that nobody could drive a commercial vehicle prior to 2018 in the United States, couldn't drive a commercial vehicle if they were insulin dependent, with the exception of if they went through a very arduous exemption process. They had to see several doctors, an ophthalmologist, an endocrinologist. They had to have their history. They had to have 12 months of history that's validated. It was sent to the federal agency, the Federal Motor Carrier Safety Administration, and out in doing a 2-year period, out of 154 applications nationwide, only 5 people ever got the exemption. So it was a very tough process, but you would have had to identify yourself as an insulin dependent and treated diabetic to get that exemption. But after 2018, they made it simpler for the driver. What happened after 2018, and in the industry understood, is that if you went to your treating clinician and had verified with them and did some monitoring, and you get these monitors that get to automatically test their blood sugar level for about a 3-month period, you could complete what's called a Form 5870, and that form would be taken to the ME, and then the ME could decide whether or not you were going to be qualified. And so it made it simpler for somebody to get an exemption, but it wasn't very simple. And so basically, without that 5870 and the ME certification, a driver cannot drive as an insulin-dependent diabetic.
Thank you, Mr. Napier. So under industry standards, and just industry standards, is an uncontrolled insulin-dependent diabetic ever qualified to drive a commercial vehicle?
Under the industry standards, they are not.
If Mr. Evans was insulin dependent from 1995 until 2020 and never disclosed this, was he medically qualified to drive a commercial motor vehicle under industry standards?
The industry would not have permitted him to drive a commercial motor vehicle.
All right. Can we put up Exhibit 27, please? All right. I want to talk to you about Mr. Evans' medical qualifications or his medical certifications. Can you explain to the jury the industry standards for how a driver establishes his medical ability to operate a commercial motor vehicle?
At some point, whether directed by the motor carrier or himself, at some point, he goes to a qualified, registered medical examiner. When I say registered, they're registered with the federal government, and they put a little registration number on the documentation for his physical so that the motor carrier can verify that it was a registered ME that's certifying his medical. And on that medical form, there's a medical form that he's given to when he goes to get his physical. It has what's called a self-disclosure, a history that the driver is required to fill out honestly. The ME cannot properly certify you if you're not honest on your certification, because the ME is not your doctor. The ME doesn't have your medical record there. And so the ME requires, and it's required of the driver, to be honest on this document and to fill it out accurately so that the ME can make the appropriate decision. And on that form, the driver has to sign a document that this is true and accurate, and understands that if it's not true and accurate, it may invalidate his medical certification. And so he's got to go through this process. He gets his physical done by his ME. They'll do a urine test. They'll, do some testing on his blood sugar level and through the urine and other things. And they take his blood pressure. They're monitoring to make sure that he doesn't have high blood pressure. And if he has any other syncope issues or something like that, they've got to find out about it. And all of that's self-disclosed. And the ME then looks at that, does his physical, does the eye exam, does all the things that a doctor does to do your physical. And after that physical, the ME then certifies you to drive a commercial vehicle. Then the driver routinely takes that back to his motor carrier, and then only the motor carrier can qualify you. And so the motor carrier looks at it, makes sure it's done right, and then qualifies you to drive for them under that, at least under the issue of the medical certification.
Thank you, sir. Can we look at, can we go through those pages on the medical certification, please?
And can I put that button to zoom in on it, or?
I think they can do it.
Okay, can
Yeah.
you zoom in on it?
Can you zoom in?
I don't have a monitor up here anymore because Clint made me get rid of it.
Question 13.
Sideways.
I can make it work.
All right. Question 13. All right. Under 13, do you see that?
And
Do you see that?
I do see that,
Mr.
yes.
Napier? Okay. And what is your understanding of, talk about the medical questionnaire and who fills that out?
That the medical, that part of the questionnaire that you're showing is filled out by the commercial motor vehicle driver, in this particular case, Mr. Evans. And he's completing this part for the ME, and the ME looks at this part of his evaluation in certifying him for being certified as a medically qualified.
And what is the entry that the driver candidate has selected as to the response to insulin used? Do you know what the columns say up top?
Yeah, it says yes, no, and not sure, I
Okay,
think is
so
what
the
it says.
far left is yes, the middle is no, and the right is not sure.
Yes.
And so what is down for insulin used from this driver?
It says no, it looks like a line, and it goes line all the way down as if he's answering those three questions as if it's no. It's my understanding. At least that's how I understood it.
Mr. Napier, if this driver put no for insulin used, but the driver was actually been prescribed insulin and was taking insulin at the time he filled this out, would that be a violation of the commercial driver standard of care in your experience?
Yes, it would, and it's dictated not just by the standards of care. There's content in the regulatory standards that outline that you have to be truthful on these legal documents, and then the industry has other methodologies for ensuring compliance with it, but that would be known in our industry as a falsification of the document.
All right, can we go to the signature line on that page, please? And are you familiar with this line on the medical form,
Yes, sir.
Mr. Napier? And could you read that, please?
I certify that the above information is accurate and complete. I understand that inaccurate, false, or misleading information may invalidate the examination and my medical examination certificate. That submission of fraudulent, intentional, false information, I'm struggling to see that,
That's all right.
is a violation. I'm afraid to read that.
All right, that's all right. I think everyone can see it. Now, Mr. Napier, did you see all these forms from 2015 to 2020 or 2019?
Yes, I did.
Did Mr. Evans, was Mr. Evans' signature on that document?
Yes, it was.
Okay. Did
It's
you-
my understanding it was his signature.
Okay. And from 2015 to 2019, did he similarly answer either no or not sure on
Or left it blank.
on the insulin question?
Yes, correct.
Okay. And if during those years he was actually on insulin when he filled that out and was taking insulin, would that be a violation of the driver's standard of care in your opinion?
Yes, it would. A significant violation of the industry safety standards, because those standards are in place to prevent somebody to drive while they can have such an attack, a diabetic attack.
All right. In your experience, if a driver does not disclose whether they're insulin dependent to a medical examiner, or they don't disclose any other medical issue, honestly, how does that impact medical examiner's ability to certify that driver?
As I explained to you earlier, it's an integral part. It's important part of the whole evaluation. If you are not honest about your medical history, then there's no way that the ME can be expected to make an accurate call with regards to certification.
Mr. Napier, are there FMCSRs that govern the issue of fatigued or ill operators?
Yes?
Could you tell me that code section, please, or the reg
There is
section?
content in the regulation under 392.3 of the Federal Motor Carrier Safety Regulations. I told you I wouldn't get that technical, but that's the code section. And it says that you should not and may not ever drive while you're ill or fatigued. And if you are, you got to get off the road. And that is, we understand as part of the industry standards, we teach, as a part of that content, we teach in the industry that you're the captain of the ship. You got to make that call. And obviously, a trucking company can put in management controls and systems to supervise you from as best they possibly can and put in disciplinary programs and ramifications to get you to comply. Okay, but we often know that they're not supervised every minute of the time. And so if you have a captain of the ship that does not adhere to those rules for safety, that drives while he's impaired, while he's either ill or fatigued, he is a safety hazard to all people on the roadway.
All right, I'm not hearing standard of care testimony here. You need to steer it back into
Sure, Your Honor.
the narrow lane here.
Sure. Mr. Napier, in your experience under the standards of care in the trucking industry, do drivers receive special training regarding identifying illness or impairment issues?
Yes, as required by the standards of care, that every driver is to be instructed as to what these standards are, and drivers are trained to comply with them. And how do you comply with it? Recognize when you're sleepy, recognize when you're dozing off, recognize when you're sick, and if you're having judgment problems, and immediately get off the road. If any of those things happen, that is the industry standard for safety.
In your experience in training or in working with trucking companies, how do you teach drivers what to do if they're experiencing illness or incapacity?
Yes, again, that was the captain of the ship example that I gave to you, is that we teach drivers that they are in charge. Not even the motor carrier can have input on that. If you say you're sick, you're sick. You don't drive. If you're fatigued, you don't drive. And we teach drivers that. Not even the motor carrier can say, oh, well, just go on down to to make your delivery. If you're too tired, just do that. They're going to get in trouble if they do that. And so, no, he's the captain of the ship, and he's got to make that call.
Based on your experience and the industry standards, as you understand them, standards of care, if a driver has uncontrolled diabetes and will not take insulin, is that a situation where, or how would you handle that situation?
First of all, we teach drivers to follow their doctor's orders, and especially if they have, like, for example, high blood pressure is a big problem in our industry. And so we teach drivers to make sure they take their medication, keep their blood pressure under control. Because if you have high blood pressure, you can be disqualified from operating a commercial motor vehicle. And so we teach drivers to recognize that they have to take their medicine, they have to do the monitoring that they're required to do, and if they show any symptoms at all from whatever their illness is, they got to get off the road.
All right, let's move on. You also mentioned that Transcontinental played a contributing role in making this a preventable occurrence
Yes,
under
sir.
industry standards.
Yes, sir.
Can you talk a little bit about that? Talk about preventability analysis under industry standards and what you observed with respect to Transcontinental and what they did.
Transcontinental failed to properly establish and communicate the effective management controls and systems that are necessary to operate safely. Absence these required management controls and systems, that the industry would find that they were contributing factors to this driver being entrusted with this vehicle and operating at the time. And so, that's the first thing. And what are the management controls and systems that I'm referring to? We don't have to have every company. Some are small, some are large, some are mid-sized. And this is a relatively small company. 90% of all motor carriers in America are made up of 9 trucks or less. So we don't accept every company and say, oh, you don't have to follow it, but we make it easier for those companies that have the certain resources. So you can go to the FMCSA and you can get all of these programs for free. You can get a safety program for free. You can get a free application for free. You can get forms for your DEQ file. You can, a lot of stuff that's out there doesn't cost you any money, but typically people start trucking companies that have the knowledge, and they sign an oath that they have the knowledge to do this. And so these management controls and systems in this particular case is over the issue of supervision. They weren't properly supervising and vetting their driver, this driver. They failed to review the medical examination report. They failed to take a proper application. They failed to do the required background and character checks. They failed to get an MVR. They failed to do a pre-employment drug screen. And that automatically makes it so he was disqualified to operate. You can't operate till you do a pre-employment drug screen. And so there's a number of those things that were not done. And the fact that they didn't have a driver qualification file is a critical violation that shows the lack of management controls and systems. And that's defined by the FMCSA and audits. And so those are the type of management controls and systems that were not in place that allow for Mr. Evans to drive this truck.
I didn't hear any standard of care testimony in there. I just heard a lot of examples. We need to fix that.
I said the industry did.
I mean, is the standing objection still there, Your Honor?
Yes.
Okay.
I'm addressing the standing objection. So I'm addressing your standing objection, Mr. Fletcher.
All right, Mr. Napier, please limit your testimony to the industry standards.
And I, just in response, I thought I said the industry treats this like this. And then I pointed out this, it wasn't examples, these were actually what they did.
The industry and the industry standard of care are two very different things
Oh,
in this
I'm-
world.
I'm
The industry
conflating
is the trucking industry. The industry standard of care is the question that you're here to opine on. And again, the jury is not required to accept your testimony, or they can as they see fit.
I
Your
understand.
Honor,
Your Honor.
if we may approach.
Hey, Clint, as soon as they're in the hallway or in there, I'm going to start a conversation. Don't let them come back in until you get the all clear from me. Is there anybody out in the hallway?
There, it's the bathroom door.
Okay, let's just close the door and let me talk to them for a minute. Mr. Scholl, I gave you a lot of ground, and I wanted to have this witness testify just like any other expert witness, that there was a specific standard of care and that this was it. I hear him saying a lot about how if he doesn't do this, then he's violated the regulations, and then that's not what I had in mind. I had in mind, you almost hit it when you said you had him put up the regulation that gave the jury the basis, and then you moved on to the next topic. But then he is tying it directly back to the regulations, which is exactly what I said I didn't want him to do. And Mr. Fletcher is nodding vigorously because I'm frustrated. I wanted a very specific set of testimony, and I gave you wide latitude, and I'm not seeing it. And I've already had to interrupt twice. So that's it. I'm just frustrated. Go ahead, Mr. Fletcher.
Your Honor, in the water area we did earlier, there's no written industry standard, and he just was rattling off violations which go to the regulation that is written. And he didn't, I mean, he's backdooring this, Your Honor, by saying it's industry standards when he's rattling off language and using language from the statute. That they didn't go get an MVR. The regulation says you're supposed to get an MVR. That they didn't go get an MCS 8750 or whatever the form was. That's in the regulation. I mean, there's no way to put the toothpaste back in the tube. And I appreciate that Mr. Napier is trying to argue for his own testimony, but I also think that's highly inappropriate for the record.
Okay, I know. And he and I have already come to terms with how we're going to do these moments. So, Mr. Scholl, anything else before I give some directions and we resume this?
No, Your Honor, I believe my question was within the confines of what you wanted.
I have no issues with your questions.
Okay.
I have issues with his answers. Your questions are spot on, and if he answered your questions, then we wouldn't be having this conversation. But he takes a deep breath and then he wanders off, and then it's usually the second half of his answer that gets us with me having to lean forward. Now, Mr. Fletcher's objection, I've overruled that specific piece. I get your point, but there's a little bit of valid in there in that he said on several occasions, the industry. Well, the trucking industry and the industry standard of care are no more connected than the city of Griffin in Pennsylvania and the city of Griffin in Georgia. They might have the same name in them, but it's two totally separate things. So I'm just saying he's not testifying to the standard of care. He's testifying to the industry, and then he's tying his testimony to the regulations. So I just need you to take a minute, and I need you to remember the purpose of your testimony is to provide expert testimony on the standard of care that is owed.
And I have a question, Your Honor.
You can ask the question.
Your Honor, I did say industry and I omitted standards of care, but I was referring to the industry standards of care by using industry. So I will correct that.
Because that's two different things.
I understand your point, Your Honor, and I was short stopping my answer. But what I was talking about was the industry standards of care and I don't know how else to testify, which is why I'm going to ask this question, about the management controls and systems that are designed by the industry standards of care, okay? The industry standards of care, which include those things that you have to do to qualify a driver. And all of those things that I listed were not examples. They were specific standards that were violated in this matter. And so that I wasn't giving example. Those were actual violations in this matter and of the standards of care. And so I don't know how to testify not doing that. That's what I'm asking.
You need to listen to me. What you testified to, you didn't say, you said industry, and then you pivoted to the regulations. You did not say standard of care. I know this sounds like magic language, but it is critically important to your testimony that you understand that you said the industry and then you said the regulations, which is exactly what I said we can't do. I know you misspoke. I know you were talking fast. You do talk fast. I'm sure Terry is working very hard to keep up with you. But you also take a breath and keep going. So here's what we're going to do moving forward. You're going to take a big, deep breath, and Mr. Scholl wants more information. He'll ask you for more information. But once you finish this point, I want you to take a deep breath and let Mr. Scholl, because Mr. Scholl's questions are spot on. And if you listen to them carefully and you follow them, you and I will be just fine. But I'm just saying, you're talking so fast that instead of industry standard of care, you said industry, and then you tied it to the regulations, and the jury is left with the idea that you are giving an opinion that he violated the regulations, which is exactly what I'm trying desperately not to have happen. Do you understand what I'm trying to say? You are not qualified to testify no one here is. There's no witness who can say that somebody violated something. You could say standard of care, and then the jury makes the final decision.
I asked you a question, Your Honor, and I want to make sure that I understood it. You told me earlier that I could say that the regulatory content was part of the industry standards of care.
Yes.
And that's what I did. That's what I did in my testimony. I went back to pivoted to the regulations and then say as adopted by the industry, and I should have said industry standards of care. By the industry, I said that these things weren't done. And so that's why I don't know what I did wrong.
I don't think you understand the critical importance of this language for the purpose of this trial.
Okay.
The standard of care cannot be understated, the importance of those words in this trial, because I'm going to be charging the jury on the standard of care, not on the industry.
Okay, I understand. I understand that mistake, but I want to make sure that I can incorporate the regulatory content with the industry standards of care.
Okay, well then, since this isn't working, the answer is no.
Okay.
So because
Wow.
I gave you the latitude, it didn't work.
Your Honor, I think the only options here are two. And we're going to move for a mistrial because you can't put the toothpaste back in the tube after so much latitude you've given him. The only other option aside from a mistrial is to dismiss the witness and instruct the jury to disregard everything he said. But even then, I mean, the bell has been rung. And it's just backdoor testimony masked as industry standards. When he starts out talking about, well, these are the means and methods to do what the regulation says, but then he's listing off, and we can go back in your chambers and pull up the regulations in the Green Book that call for the certain things to be done. And it's just backdoor testimony. And so if you're not going to order a mistrial, then we'd ask that he be dismissed, because it's obvious he can't recognize the line.
Okay, I understand that. I'm going to let us continue at this point, because frankly, the mistrial is denied. I recognize why you're asking for it. I don't believe we are there yet. We have one witness that's gone sideways. Again, I want to be very clear. Mr. Scholl's questions are great. And if those questions were being answered, then that would be fine, but they're being answered and then added to. And I'm not hearing the terms that are essential to this witness's testimony. So we're going to start back. We're just going to let you ask your next question, and you're just going to listen carefully to Mr. Scholl's questions and answer that question.
And Your Honor, because he's speaking so quickly, we're just going to have to object contemporaneously. And I've got 3 eager ears over here ready to jump up. So
Okay.
3 pairs of eager ears ready to jump up.
That sounds fine. All right. You can bring the jury back in, or you can let the jurors back into the room. And as soon as they're all ready, we're ready to go. All right, if you'll just tell them just to knock when they're ready. So, oh, we can do this monitor real quick. Do you have room right there? Let's see if we can see it here. Mr. Fletcher, grab that seat right there and tell me if you can see. Here, grab a seat. Let's just see.
Yeah, well, I mean, that's much better. Yeah, I mean, where it was, I couldn't even see his face.
All right, well, let's plug this monitor in and let you have. I don't have my glasses here. I think that's me making all that. We'll be okay. Okay, so obviously when you talk, don't bump it. I'll give it here in a second. I just need to put some stuff. That's it. That's all I need. IT, y'all. Give me just a second. Did I mention I used to be a judge? And then I became an IT guy and a video producer and everything else. All right, so, yeah.
Liz, can you put up
Just push anything up.
a mouse or something? Yeah.
Okay. That should let me see it better. All right, you may ask your next question.
Thank you, Your Honor. Mr. Napier, could you please walk us through how a responsible motor carrier following industry standards medically qualifies a CMV driver?
Yes. They send the driver to a medical examiner, and while at the medical examiner, motor carrier ensures the driver fills out proper forms and makes a proper health disclosure, and the ME will then certify, after giving an examination, will certify the driver as being.
Your Honor, may we approach?
okay so far, thank you.
Thank you, Your Honor.
Thank you, Your Honor. All right, Mr. Napier, without referring to the FMCSRs, can you walk us through again, how does a responsible motor carrier following industry standards qualify a CMV driver to drive a truck?
Am I allowed to repeat the same answer I just gave, or is it wrong?
Just don't refer to the
didn't earlier,
FMCSRs.
so-
Okay, thank you.
The motor carrier would send typically their driver to a medical examiner that they know is properly registered. They would require the driver to complete the form of his health history, and the ME would get that form and would provide a medical examination. And then that form, the medical examination report form and the certificate would come back to the motor carrier, and the motor carrier would look at it and see if it's okay, and then go forward, either requiring the ME to look further or to get clarification or to or otherwise, but to make sure that it's been properly completed, because it's an important document.
Mr. Napier, based on your experience in the trucking industry as an owner of a trucking company, what is the industry standard for a trucking company in choosing a medical examiner? Or does the trucking company choose it? Does the driver choose it? How is that generally handled by a trucking company?
This is an industry standard issue not covered by the regulations, so the industry standard of care that is been developed by the industry, by the North American Transportation Management Institute, and that trains people like me in this industry, and as does other stakeholders, teaches motor carriers to vet their own ME, to have an ME that they feel comfortable with, that knows the job description of your truck drivers, that understands what you expect with regards to vetting of the truck driver and doing a full medical examination. And so you do that, and then one that also communicates with you and sends you the proper documentation as well, because this is one area that the industry standards understands is not controlled by HIPAA, because this is controlled by safety.
Can we put up Plaintiff's Exhibit 18, please? All right. I'm going to represent to you, Mr. Napier, that this is the application for employment for Mr. Evans to Transcontinental Carriers. And can we scroll through that document, please? All right, and that's signed by, is that dated, Mr. Napier?
No, sir.
Okay. And can we go up, please? Let's just start with that page. Does this appear to be filled out properly according to industry standards for applications in commercial trucking carriers?
No, sir. It has it has to be completed. All blocks are supposed to be completed, and it doesn't even have all of the required information on this particular application.
All right, can we go to the top page, please? All right, thank you. And what is the name of the applicant for this job?
Mr. Jeff Evans?
Okay. And do we know when this was, do you have any indication of what the date on this was?
No, this is not dated, and the industry standard would dictate has to be dated.
Okay. Now, talking about these industry standards, and you talked about trade groups earlier. Are these industry trade groups, are those difficult to join to learn about the industry standards?
No, they're not. I think I'm a member of the Georgia Motor Trucking Association. I think I pay $350 a year for that membership. It provides all kinds of information for compliance with regulations and the industry standards. It has all kinds of training available. And then you don't even have to be a member or something. You can submit for, if you work with J.J. Keller, you can pay for certain videos and stuff like that to have. But there's, you can attend Georgia Motor Trucking Association seminars for very little. But and the network of other motor carriers is encouraged by the FMCSA as well.
All right, Mr. Napier, you live in the Macon area, you practice in the Macon
Yes.
area?
Yes,
Okay, and are there medical examiners there?
Yes.
That work with trucking companies that are unaffiliated with the drivers and independent?
yes.
Could you name some of those?
Well, the primary one in Macon, Georgia is called Macon Occupational. And it's the one that that where most drivers in Macon go to and motor carriers send them to.
When you were running your own trucking company, would you ever send a driver? Would you ever accept a driver's medical certificate if they chose their own physician?
No, I did not.
Okay. Would you ever accept one from a
Part of the
chiropractor?
industry standards for having management controls and systems for ensuring that that you're supervising the process and properly vetting a driver.
And would you ever accept a medical certificate from a chiropractor?
I wouldn't, but the regulations, I'm sorry, but it is permitted.
Okay.
But the industry standard doesn't prohibit it, but as a matter of practice, I would not have.
All right. Your Honor, I think I'm done. Let me just, can I confer with Mr.?
Yes. Set this on your monitor.
All right. Your Honor, I'm done with my question.
All right, Ms. Fletcher, you may cry.
Thank you, Your Honor. Give me just a minute here to just get set up, please.
Sure.
Mr. Napier,
Yes, sir.
just get ready.
Oh, I thought I was waiting for you.
Yeah, no, I was getting your attention. First off, just for the record, my name is Clinton Fletcher. We talked outside and we know who each other and we've met. First off, thank you for your service. My dad is also Marine, so I can appreciate that.
Hoorah.
Purpose of this cross-examination is try to get to some areas where we agree upon. And I'll be asking you questions to see if we can get to those places. I kind of want to start with just focusing on your background. You talked about an Exhibit 34 that was just pulled up there, Plaintiff's Exhibit 34, had your industry-specific experience.
Yes,
It
sir.
listed regulatory and industry standards for safety and compliance. Did I read that correctly?
Yes, sir.
All right, and the jury just heard a whole bunch about these industry standards. Is that correct?
Yes, sir.
All right, and that forms the basis of your testimony.
Yes, sir.
Yeah, and you relied upon your experience and your study of the industry, correct?
That's correct.
Okay, but as we sit here today, there's no actual book that lists out these industry standards, is there?
No, sir.
Okay.
There's hundreds of books,
I know,
but no one book.
Yeah, but is there one book that you can cite that says industry standards, section 1?
No, but I have a book that has a whole binder of industry standards that purport to be industry standards in separate areas, but I don't have one book that says that. No, that's why my experience is necessary.
Okay, and your binder, is that full of a whole bunch of different periodicals and
Sure.
references?
Yeah, that's correct. Everything from the Federal Motor Carrier Safety Administration to stakeholders in the industry and studies and the National Board of Academies and all that refer to the industry standards as a methodology.
Okay, but in terms of the published regulation as to what motor carriers, those are what they're supposed to do. That's the federal motor carrier safety regulations, correct?
Would you repeat your question?
Right. But the published document that anybody in this room can go to know what any motor carrier from small to large must follow. That starts with the federal motor carrier.
Those are the minimum standards of care for, which implies by itself they're not the only standards.
Yeah, the minimum standards, that's what you call
No, the government does. I provided you that in my talking points. The government, under a certain citation, says that they are minimum standards of care, and I can provide you a number of references that the FMCSA says it is, and the stakeholders all agree that these are the minimum standards, and if you try to comply with that, you may not be a safe company.
them. Yeah. And these regulations, they lay out line by line what motor carriers are supposed to do.
For the enforcement standards, that's correct.
Okay, and in terms of what those motor carriers have to do at a minimum to operate their business, it lays out specifically what they're there to do.
I don't mean to qualm with your verbiage, but I don't agree you can operate and be not in compliance. If you operate not in compliance, there can be enforcement actions for your non-compliance.
Okay.
But
so
you're getting me into the regulations and I'm getting ready to get yelled at.
Answer the question
Okay.
that's asked.
Yeah, I'll take your answer as a yes,
Okay.
because the question was, the regulations lay out what a motor carrier is supposed to do, correct?
For the minimum standards, not all standards, no. And as I gave you some examples earlier why that's not the case.
No, I understand you're gonna say that there's the extra standards that a company is supposed to follow, but the standards that all motor carriers must start with are the federal motor carrier safety regulations,
No,
right?
sir, those are the enforcement standards, and the other standards are part of the safety standards for a commercial motor vehicle industry. And those industry standards are known to be the reasonable standards of care for operating a commercial motor vehicle.
Understood. And when Mr. Scholl put up there the regulation, that was the federal regulation that he put up there, correct?
Yes, that's
Yes.
what we were
And
looking.
during your testimony, he didn't put up there what a written industry standard was, did he?
No, that's what I'm here for.
Because if it was written, you would expect that Mr. Scholl would have put that up on the screen, right?
I can give you a whole lot of training material, sir, that will say the same thing, but as I testified earlier, the industry standards of care, the basis and the genesis begins with the enforcement standards, the regulatory standards, and then morphs into the reasonable standards for operating. And one has to have the other. They're entangled together. It tells you, for example, how the regulations don't tell you how fast you can drive. The industry standards tell us under certain circumstances. The industry standards don't tell, or the regulations tell us you have to have management controls and systems. But the industry standard tells you what those management controls and systems are. And so without one, you can't do the other.
Yeah, I understand you're passionate about this, but the answer to my question, I think, was yes. The written industry standards were not put up on that screen for the jury to view, right?
The answer was yes, but it was why I'm sitting here today as an experienced expert, is to tell you what they are. And that's why you're supposed to argue with me and get vigorous cross-examination to see if I'm right.
And let's talk about that experienced expert background that you have.
Okay.
Attached to the back of Plaintiff's Exhibit 34, which was not shown to the jury, I counted roughly from 2019 to 2023, 71 cases where you have testified in.
I assume you could count correctly. I've never counted it, so.
Well, I'm a lawyer, that's why I went into law, because I can't count. But it took me 3 times to count through it. So I counted 71. You wouldn't have any.
I wouldn't have, I think it's now about 89 up to date, but anyway, it is what it is.
And then you talked about earlier, when Mr. Scholl asked you how much you've charged his client for your testimony and your review. I think you said it was $27,000.
Well, he didn't ask me that question. That wasn't the question he asked me. He says, how much have you charged for your services? And my client is only the law firm, period. I do not work for any plaintiff or defendant. I don't work for insurance companies, and I don't work for plaintiff clients. I work only as a consultant and an expert for the lawyer. And so the lawyer firm has paid my firm, the number I gave you, I think was $28,000.
Yeah, and that was 28,000 up to today.
That's correct. And I don't know, again, it was 3,500 for my appearance plus preparation time. I don't know the number right now.
Okay, and today's your testimony, it had you had a positive opinion for the defendants, you probably would not be here talking on behalf of the plaintiff, right?
If I had I'm not sure that I understand
Yeah.
your question.
If you had opinions that were favorable to the defendants, you wouldn't be here as an expert on behalf of the plaintiffs, right?
I would agree with that. If the facts didn't fit, then I would have told them I couldn't testify.
Yeah. And then you wouldn't be paid the $28,000, right?
I'd get him on the next case.
Because that's predominantly your area of what you do to make money, right?
Sure, I've worked for your firm before, and you paid me, and I didn't get used on one occasion. So, I mean, it's the way it works. And when you're a good expert, you get hired. I'm not worried about whether he fires me or not.
All right, you talked about how and I'm summarizing here, I don't want to restate the question or your testimony, but to summarize, I think you testified that the federal motor carrier safety regulations somehow trump HIPAA privacy laws?
No, I did not say that. I said the Department of Transportation trumped that, but the HIPAA laws are not applicable as it relates to sharing of information with a motor carrier on the physical qualifications of the driver.
Oh.
There's a release that's signed by the driver, usually on the application or otherwise, but those releases are routine as a matter of practice in our industry, and those releases allow for the sharing of information because the HIPAA laws are between insurance companies and healthcare providers.
Okay, you're not an expert on HIPAA laws, right?
Only as it relates to the trucking industry, but I'm not a HIPAA guy.
Okay, so if I understand your testimony, that this waiver to get this medical information, this waiver that to allow an employer to get the driver's medical history, that waiver, that's not specified precisely in the statute, is it? That's just the industry.
You're calling it a waiver. You mean the release?
The release, yes.
The release is covered under the Department of Labor regulations under CFR 29, and so that's why the release is done. And under the Department of Labor, they recognize that they do not govern the trucking industry with regards to sharing of healthcare information.
Federal motor carrier safety regulations, is there anywhere that you know that you can cite to the regulation that says a trucking company is required to get the full medical history of their drivers?
No, so you're mischaracterizing my whole answer. I never said that was ever plausible to do. All they're supposed to do is answer the questions honestly on the form.
My question to you, Mr. Napier, can you state for the jury the specific federal regulation that says a motor carrier is required to ask the medical history of their driver?
Okay.
From head to toe?
That's a different question, and I will answer that question. Yes, under the regulations, under 391.41, it says that everyone must be informed and knowledgeable and instructed of this part. That's 391 in the regulations. It says it requires that. And in that regulation, it lists specifically those things that are supposed to be disclosed to the ME. And guess what? It's only applicable under 391.41 is applicable to the motor carrier and the driver. And so, yes, I would tell you yes, but again, I thought that I wasn't going to do this with regulations. You're wanting me to testify on the regulations now, and earlier you didn't want me to.
I was asking you if there was a regulation that specifically said that.
I thought the judge told me not to talk about regulations.
The judge's orders are the judge's orders, and I think you're misinterpreting it.
Okay.
But if I understand your testimony, is your testimony that you believe that a motor carrier is required to know the full medical history of their driver before they put him on the road?
I said the motor carrier is required to ensure the driver observes the regulations, and the driver has to comply with 391.41 and disclose his medical history to the ME.
All right,
So
and you're
yeah,
not a, sorry, I didn't mean to interrupt.
So that's the requirement.
Okay, and that's the disclosure between the driver and the ME, right?
That's correct.
Okay, and you're not a medical examiner, right?
I'm not.
Okay, you've never become a certified medical examiner.
I'm not.
Okay, and a certified medical examiner, in terms of your understanding, a medical examiner just has to be someone who's listed in the regulations as qualifies to be a medical examiner.
I believe that's correct.
Okay, and so a medical examiner in in the statute lays out what specific healthcare type providers can be a medical examiner.
It does.
Okay, now that we're on the topic of the medical examiner, though, Mr. Evans did go see a medical examiner, right?
Yes.
And he was a certified medical examiner, right?
He was registered. Yes.
Okay, and you even pulled back the curtain to go see if Dr. Robert Hayden, the medical examiner, was certified, right?
He was registered. Yes.
Yeah, and where do you go for that registration?
To the National Registry.
And you went to the National Registry,
I did.
right? And you typed up National Registry, DOT, whatever it is, and it pulls up a sheet where you can put in to find a medical examiner, right?
That's correct.
Sorry, Ryan, I'm getting too close. All right, and when you did that for Dr. Robert Hayden, you entered his name, first and last name, right?
I did. I've answered this question. He was registered properly. Yes.
Well, the jury's not as familiar with you on these industry standards or regulations, so we kind of have to walk them through.
Okay.
All right, so you went to this website and you pulled it up and Robert Hayden popped up, right?
Yes, he's properly registered.
Okay, and have you done any examination as to whether Robert Hayden has been sanctioned or decertified?
No, I have not seen that he's been taken off the registry.
And you don't have any evidence that he has been reprimanded for doing fraudulent medical exams?
I never said he did a fraudulent medical exam.
So that's a no. You didn't see that he's been reprimanded.
But the preface of your question was that, yes, that's a no. I did not see that, and nor did I ever am accusing him of doing a fraudulent. I'm accusing the driver of not properly disclosing his medical history.
Okay, but that's only your opinion that he didn't properly disclose his medical history.
It's on the form.
Okay.
I'll let the jury decide that.
Yeah. You testified earlier that when you were getting qualified, that you have a CDL, right?
Yes,
And that you had let your medical certification lapse.
I have.
All right, that means you haven't gotten your every year or every 2-year medical certification.
That's correct.
All right, but you sat in those medical certifications, obviously.
Many times.
Okay, when was the last one?
About 2 or 3 years ago.
Okay,
I
so
just recently let mine lapse, so
completely understand. You're probably not having to drive a commercial.
I'm not.
Okay, so it's not that long ago that you sat through one of these.
Yes.
Okay, so when you sat through this, let's walk the jury through this. You go and you pick a certified medical examiner.
Yes.
Okay, and you would testify that some motor carriers, they like to have one that they prefer and send their drivers there, right?
I say that's a standard of care in the industry, yes, but I did say that.
Okay, but the regulations do allow that someone can go choose their own medical examiner.
It does, but the regulations also allow for more stringent standards to be employed. So
All right, so Mr. Evans could go choose his own medical examiner.
under the regulatory standards, it does not prohibit that.
All right. And for you, when you went and saw the medical examiner, you go in to meet with the medical examiner, right?
Yes.
All right, you fill out that medical long form that asks your medical history.
Yes.
All right, and then you check the boxes of what other ailments or illnesses you have, right?
Yes.
Okay, and that information, you're providing him your medical history, right?
Yes.
All right, but you're not a doctor, right?
No.
Okay, you don't have the experience of a medical background, right?
No, I don't. No.
Oh, okay, so, when you go and fill out this form, sometimes you may have questions, right?
I don't understand what you mean.
You may have some questions, hey, medical examiner, how should I fill this out? Right?
No, I don't have any questions on saying yes or no.
Okay, so, yeah, good.
It's a yes or no question.
That's a good point. So when you're going through that form, you check yes or no, like you said, right?
Yes.
Okay, and then what if there's a box that's left open? Would you expect the medical examiner to ask, hey, why is this left blank?
or the motor carrier to have done it. That's what I would have expected.
Let's talk
But
about
again, I'm not a medical examiner, so I'm not testifying as to the medical examiner. I'm testifying as to what the motor carrier should have done.
Okay, but when you went and experienced and sat in with the medical examiner, did you have a conversation with that medical examiner?
Sure.
And he went down the form with you?
No, I think that there were some things that I checked no on or yes on, and they double checked my blood pressure. And the last one I got was for 1 year because my blood pressure was too high, and so that was the only discussion we had. But I answered the question and put down the medicine I was taking.
Yeah, so it wasn't like you handed him the medical long form and then he just stamped it clear. You had a conversation with him, right?
Sure I did, yeah.
Yeah, and he asked you, let's take your blood pressure, right?
Based on the fact that I said I had a history of high blood pressure.
Right, and then because you checked on there, like high blood pressure.
Right, and then they took my blood pressure twice, yes.
Yeah, so in the medical examiner, he had this conversation with you to learn more about you, right?
Yes, maybe, that's correct.
Yeah, and he had this opportunity to ask you questions if he had any, right?
I guess, yes.
Yeah, and I'm sure during your medical examination, to be able to qualify you as fit to drive a truck, he would have said, hey, how are you feeling today?
He didn't qualify him, he certifies. Only a motor carrier can qualify.
Okay, to certify you
You
with the
can
medical.
laugh at me all you want, but words are important here, aren't they?
Completely
So
agree.
let's not laugh at each other, okay? I'm trying to give you accurate testimony.
I understand.
All right.
All right, to certify you as medically qualified, he asked you questions about your lifestyle.
That's correct.
He asked you questions about what you've experienced recently.
If it was relative to my medical history, you might have. I don't remember the conversation. I remember talking about my blood pressure.
And if the form was left blank, you would expect him to say, hey, Mr. Napier, why didn't you check this?
I would have guessed that they would have ensured that I had to fill out the form, yes. But the motor carrier is the one that's ultimately responsible for qualifying a driver.
Now, in terms of the federal motor carrier regulations, there's no clause that says you must follow industry standards, right? That language.
No, the regulations has a section in it that says you may use more stringent standards than are in this. And therefore, the industry has developed those reasonable industry standards of care for safety that are not codified by the regulations.
Interesting. We just had this little colloquy about that words matter, right?
Yes,
Okay. And you just stated that you may follow the industry standards.
I didn't say that.
We can go back and ask the court.
I don't know
reporter
what
to
you
read
meant
it back.
by may. I said that you
No.
can use more stringent standards.
You could, or you may. And I can go back and ask the court reporter, because my question was, is there specific language that you are required to follow the industry standards? And your response was, yes, there is. A motor carrier may follow standards that are higher.
It does say that, yes.
Talking about the medical examiner and what he did, Mr. Evans had a medical certification for 2015, right?
He had a certification for 15,
2015.
I believe, yes, so we had 15, we had 5 years worth, so.
You're stealing my thunder here. Let me just go through each
Okay,
year. My question was, Mr. Evans had a medical certification for 2015.
I
Yes?
believe that's true, yes.
Mr. Evans had a medical certification for 2016. True?
I do believe that's true, yes.
All right. Mr. Evans had a medical certification for 2017. True?
I think that's true, yes.
Mr. Evans had a medical certification for 2018. True?
That's true.
And Mr. Evans had a medical certification for 2019. True?
That is true.
And all those medical certifications were signed by Dr. Robert Hayden. True?
That's correct.
Right. And you would expect that Dr. Robert Hayden would have performed a thorough examination of Mr. Evans to make sure, for purposes of his med card, that he was certified.
I don't know what Dr. Hayden did or didn't do. I have no information, no evidence otherwise whether he did well. But I will tell you, 4 out of those 5 were answered incorrectly. And so therefore, the ME wouldn't have had any information at all regarding his health history of being insulin dependent. So I'm not here to criticize an ME. I'm not an ME, but as a motor carrier, if you would have come back with a positive reading in your urine, I would have questioned that certification.
I appreciate your extra response to my question, but my question was, you would expect that Dr. Robert Hayden did a thorough examination of Mr. Evans.
And I said to you, I'm not here to testify what he did. I don't know what he did. I don't know whether it was appropriate or otherwise. I can tell you, as a motor carrier, I would have questioned it. That's all I'm trying to say to you.
And there's nothing in the FMCSR that precludes a chiropractor from being a medical examiner, right?
I thought we answered that question. I do not believe there's anything that does.
In this case, Mr. Napier, I think you testified that no 7-year MVR was pulled by transcontinental carriers, right? Did I understand your
believe that-
testimony?
The record, there was no documentation for it.
Okay. And so you've never seen a 7-year MVR for Mr. Evans?
Yes, there was one that's been produced in this case that was, I don't know if you guys pulled it or the plaintiff pulled it, but there's a lifetime and it was disclosed in the case, so.
Yeah.
Right.
And that MVR did not show any prior accidents relating to a diabetic attack, right?
No.
Okay. That MVR, and an MVR for the jury stands for what?
Motor vehicle record,
And what's the purpose of the motor vehicle record?
it's to vet the safety background of a individual driver.
Okay, it's basically like a collective area where if there's been any accidents or any charges for motor vehicle violations, it's listed in one document that people can ask for, right?
Well, not necessarily for commercial drivers. The CDLIS would usually have that particular document and or what's called the pre-screening program, the PSP, as for a commercial driver. So it's not the end-all be-all for your entire motor vehicle record is what I'm trying to say.
Okay, but in terms of the motor vehicle record for Mr. Evans, you've seen the motor vehicle record for Mr. Evans?
I did.
Okay, and the motor vehicle record did not show any prior accidents before July 1, 2020.
I did not see that, no.
Now, you talked about, Mr. Scholl put it on the screen. He put up the job application for Mr. Evans at Transcontinental Carriers.
Yes,
Okay, Transcontinental Carriers, actually, there was a company that preceded Transcontinental Carriers that Mr. Ogletree ran, correct?
yes,
Okay, and then in your understanding, Ironweld then became Transcontinental Carriers. Is that your recollection of review of the file?
my understanding is they went out of business after having a significant fine and a conditional rating by the FMCSA.
Okay, but Ironweld, it employed Mr. Evans, right?
At some point it did, yes.
Okay, and there was a job application by Mr. Evans at Ironweld, correct?
I don't have that in the file, but
Your understanding?
I'm understanding there would have been.
But was there a job application by Ironweld for Mr. Evans?
I'm assuming there was. I mean, I just don't have a specific recollection. I wasn't going to talk about iron-willed, but I don't have a recollection of looking at that document. Doesn't mean I didn't.
Right. So if we showed a job application for Mr. Evans when he worked for Ironweld, you wouldn't necessarily have any reason to disagree with that at this point.
No. I just would say it's not applicable to this case, so.
All right, but Mr. Evans worked for Ironweld, right?
Sure, but there's specifics, standards of care that would prohibit a driver that has been outside of the operation of a motor carrier for a period of 30 days.
Your Honor, I'm going to object. He's adding and he's not answering my questions. And it's pure colloquy. And I've narrowed my questions to yes or no. And he's just continuing to testify. I'd like to move to strike and ask the jury not to consider this extra substantive as answers. If I ask open questions, you can't.
Denied, you have him on cross. Ask your next question.
And obviously, Mr. Evans had his CDL at the time of this incident, right?
He had a CDL, but he wasn't qualified to have the CDL, yes.
Oh, no, we've heard your opinion on that fact. I'm just asking simple questions. He had a CDL that had no restrictions, right?
Right, just like I hold a CDL myself, but it's not in effect because I don't have a medical certificate.
Okay. Mr. Evans had a medical certificate at the time of this incident, right?
That we know that was obtained because he didn't properly fill out his long form, and the fact that he was insulin-dependent diabetic.
Yeah, and if that long form was not filled out correctly, Dr. Hayden could have asked him why it was not filled out correctly.
Again, I'm not the ME, so I'm not testifying about the ME.
We talked about the MVR, and that goes to whether the driver has had any significant accidents or motor vehicle violations, right?
The word any is just, it is a source, yes.
Okay, but it would, if it had any accidents or moving violations, you would expect that it would show it on the MVR.
It could, but there's other sources. But yes, I'm not denying that it is a proper source.
And your testimony was the industry standards require that motor carriers go that extra step?
Yes, that they would go and they make sure that they get an MVR from the CDLIS, that's the Commercial Driver's License Information System.
Okay.
As well as doing what's called a pre-screening program report from the FMCSA. And that tells you all the violations that a guy would have while driving a commercial motor vehicle, or any crashes that he would have had while driving a commercial motor vehicle that may not be necessarily on the MVR.
Okay, and you would defer to the motor carrier, federal motor carrier regulations in the four corners of it as to what is required of that motor carrier to confirm the driver history.
Again, I'm here to talk about violations of the industry standards of care, and it's a violation of the industry standard of care not to have gone, because the regulations also state that you should use all available, reasonably available information, and under 391.25. So yes, I think that does kind of dictate you're supposed to do your criminal background check, your PSP, your CDLIS, and MVR.
Right. Now, you talked about a pre-employment drug test.
Yes.
Yes, and I think you criticized Transcontinental because they did not have a pre-employment drug test before hiring him at Transcontinental.
Yes, allowing him to operate without that drug test made it forbidden for him to operate.
All right, and you're not aware of any evidence that drugs played a part in this incident, are you?
No, sir, I'm not. I'm just saying that he was not qualified to drive because he wasn't properly qualified.
But drugs had nothing to do with this accident, right?
Right, but he was not qualified because they did not have the management controls and systems for drug and alcohol control.
Now, I kind of want to go back, talk about your background.
Actually, I think this is a great point for a break, because I've kept y'all in here since 1:30, and they had a quick break, but, so I'm so sorry, but and I had coffee, so we're all gonna take a break. So same instructions as always. The short version is don't get any information from any source I haven't told you to get it from earlier. All right, go back in, don't turn your phones on, use the restrooms in the hallway in there, knock as soon as you're ready. I'm gonna let everybody else in this side stretch your legs. This will be a very short break, y'all, very short. Members of the jury, as you will remember, just before the break, Mr. Fletcher was still in the middle of his cross. I cut him off because we're all human and I needed a break. So, Mr. Fletcher, you may continue your cross whenever you are ready.
I appreciate you making me the long-winded guy.
Is that enough? That's all right. I drank too much coffee.
Yeah. Mr. Napier, with the help of my colleague Matt Moffett, explain to the jury, what is a CDL?
What is a commercial driver's license?
Yeah.
It's a commercial driver's license.
And what does it take to get a CDL?
Routinely, you go to truck driving school, you're given specific training, you read the commercial driver's license manual, which is the basis for asking you written questions, and then you have to go to the DMV and actually drive a tractor trailer as a part of the test.
Okay, and then many people go through kind of a person like yourself to get qualified to drive a commercial motor vehicle, right?
Not anymore, but it used to be. Nowadays, you have to do a school, so.
Okay, and then to get the CDL, you get a background search.
No, I didn't have to do a background search to get my CDL.
Okay,
The only one that happens is at the motor carrier when being qualified.
okay, but you have to go through the training, right?
Yes,
Okay, you have to go through a test.
yes.
Then you have to go to the DMV and then make sure your eyes are working correct.
You have to have a physical when you go there, get the CDL.
Okay, and that physical, you have to prove that you've had that physical, right?
That's correct.
All right, because you can't get the CDL without the physical.
I think that's correct.
All right, and the CDL requires a more rigorous, I'll use not necessarily a background search like we're looking for criminal record, but the CDL has a lot more steps to jump through to be able to drive a commercial motor vehicle, right?
More steps than what?
A regular motor vehicle, like what we would drive to. the
Oh,
courthouse.
yes, sir, I understand.
And then the person who certifies that the commercial driver can get a CDL is who?
It certifies, I don't know why I use that word, the state authorizes. The state authorizes you to drive a commercial motor vehicle by issuing a CDL, but only a motor carrier can qualify you.
All right. So for purposes of Mr. Evans, he had a valid CDL at the time of the incident, right?
Other than the semantic issue that he's not qualified because of his medical certificate, and not having a medical certificate means you lose the ability to drive it. But that said, he is a CDL holder. I can say that.
Okay, but a CDL was active at the time of the incident, right? There was no restrictions on it, right?
The restriction would have been if he didn't have a medical certificate, but
I
I don't
understand what it
disagree.
would be.
I'm trying to give you your deference, okay? I know that he's holding a CDL, and it was a active CDL, but it wasn't valid because of the medical certificate.
All right. So at the time, in holding that CDL, he was properly licensed by the state of Georgia to operate that commercial vehicle.
I don't disagree with that, but that's not the end all be all, but
And then prior to the incident, Mr. Evans, as we testified, he had a clean MVR, correct?
Transcontinental didn't know that, but I understand. They didn't do any MVR check, but we don't have all the records. We don't have the PSP, we don't have the CDLIS.
The 7-year MVR. You've looked at the 7-year MVR.
And I said to you, that's only in part the record.
And it was clean.
Basically, yes.
And we testified, he did in fact have this medical certificate at the time of the incident, a valid medical certificate.
I'm going to quibble with you on the validity of it.
There was
but
nothing on the face of that medical certificate that was wrong, right?
He had a certificate signed, but it wasn't valid.
Now, you have not drafted any or participated in any drafting of federal motor carrier regulations, right?
I have not. I've just been the guy that had to comply with them.
Yeah, you've never submitted anything in public comments to the feds about what your suggestions are for the federal motor carrier safety regulations.
I do not do that. I just comply with the federal regulations and the standards of care for safety.
And you're not certified. You don't have a nice little certificate you put in a frame up on the wall that says, I'm certified as an expert in industry standards. You don't have one of
I don't
those.
have one of those things, no, but I've been qualified by courts all over the United States as an expert in trucking regulatory and industry standards of care.
Okay, aside from the courts, how about any industry association that certified you as an expert?
No, I didn't seek the certification. I sought the education, and I have completed all educational requirements by the North American Transportation Management Institute to include all of the experience level and the prerequisite course taking. And because I'd already been certified in many courts as an expert, I didn't seek the certification. I only sought the education.
So you didn't seek the certification of the industry that you're speaking on behalf of?
I did not, no.
All right. And you've not authored any peer-reviewed articles about industry standards?
I don't author peer-reviewed articles, no.
Okay. No further questions, Your Honor.
Just a couple, Your Honor. Mr. Napier, are you familiar with the law firm, Mr. Fletcher's law firm?
Very familiar.
Have they hired you before to be an expert in their litigation cases?
They have, and they're pretty good lawyers.
Okay. Now, I want to ask you, are some of the, I'm looking through the book on the FMCSRs, and I see some DOT interpretations. You know what I'm talking about?
Yes, I am. Yes, I do.
Do you consider those industry standards, or do you consider those part of the Federal Motor Carrier Safety
Those are
Regulation?
promulgated to be part of as if they were written into the regulatory standards.
Okay,
And that's codified in the Federal Register.
all right. Can we put up 391.41? Can we go to the actual text of the FMCSR? I guess, let me ask you, Mr. Napier. There's 391.41. Is that the text of the FMCSR, the actual text?
It's part of the text, yes.
Okay. And then there's DOT interpretations. And what is your understanding of what DOT interpretations are?
Interpretations is when there's been comments and questions to the Federal Motor Carrier Safety Administration regarding a question about a regulatory standard. That will go before the FMCSA, the Federal Motor Carrier Safety Administration, and they will respond to that in a Federal Register and incorporate that interpretation into the regulation.
Your Honor,
Go ahead.
may we approve?
You may.
Thank you, Your Honor.
All right, that's overruled. You may continue your answer.
All right, can we go to question 1, please? Now, this question 1, can you read that, please?
Yes. Who is responsible for ensuring medical certification meets the requirements? The guidance. Medical certification determinations are the responsibility of the medical examiner. The motor carrier has the responsibility to ensure the medical examiner is informed of the minimum medical requirements and the characteristics of the work to be performed. The motor carrier is also responsible for ensuring only medically qualified drivers are operating CMVs in interstate commerce.
Now, when you were in your trucking industry and you did, you own your carrier, did you follow these DOT interpretations like that one?
Yes.
All right, thank you, sir.
Recross.
Yes,
I'm
Your
sorry,
Honor.
recross.
Recross, yep, my apologies. Can we put back up that?
That's out there with your tech team.
All right. There's minimal medical requirements that they be informed of. Is your testimony that someone's personal disease history is to be shared with their employer as the minimum?
I'm not sure that I understand your question.
You read this. The motor carrier has the responsibility to ensure that the medical examiner is informed of the minimum medical requirements. Under that, in your experience, would you expect a motor carrier to get the disease history of their drivers? And
I I think that you're misunderstanding what that says. What I understand it to say is that the motor carrier is supposed to make sure that the medical examiner knows what the minimum requirements are for certifying somebody.
Okay.
And those minimum requirements would include a accurate medical history disclosure.
Okay, a disclosure of someone's full medical background.
No, just what's on the form. It asks you all the relevant questions on the form. It doesn't have whether you have a hangnail. It's got certain things on your
Okay.
form that they ask you to disclose.
So just what's on the form.
Yes.
All right. Does that conclude everybody's questions?
Yes, Your
All right, may this witness be released?
Honor. Yes, Your Honor.
All right, you have concluded your testimony. You are released from your subpoena and you're free to go or
Thank you,
stay
Your
as you
Honor.
please.
Thank you, Your Honor.
Your Honor, technically.
Oh,
she
well,
doesn't
I
vote.
asked, sorry.
I just want to preserve the record here.
Yes, I'm so sorry. I asked Ms. Dabbs on the break, I just realized off record if she was gonna cross, and she said, no, I should have put that on the record.
That's fine, Your Honor. No further questions.
I am so sorry, Ms. Dabbs. That's my fault, y'all. All right, you missed it.
Thank you. Just a second, Your Honor.
Yes, that's okay. While he's doing that, y'all come talk to me about logistics. All right, think we're good. Ready, plan for ready to call your next witness?
Yes, Your Honor. Before I do, I'd like to move for the admission of the application of Mr. Jeff Evans. It was referred to in the corporate representative deposition and just in Mr. Napier's deposition. We'd like to move for admission of this document.
All right, what's the number?
It's plaintiff's 18.
Okay.
No objection.
All right, plaintiff's 18 is tendered and met without objection.
Oh, thank you.
No objection, Your Honor.
What else? Oh my gosh, Ms. Dabbs, now I'm just like stuck in my head about it. I'm so sorry.
It's because I'm shorter than Mr. Fletcher.
No, that's all right. I should have just done all that on the record, Ms. Dabbs. I'm so sorry. All right, any other housekeeping?
No, Your Honor.
Okay. All right, then, who's your next witness?
The plaintiff calls Dr. Todd Chapman, MD, by video deposition, Your Honor.
All right. Members of the jury, as you will remember, I gave you instructions about how to take in deposition testimony and how you're to treat them just like any other witness. The next witness is deposition that we're about to watch. I believe y'all told me it's about an hour and a half.
I don't know where Mr. Myers is.
Yeah.
I think it's an hour and 20 minutes.
Yeah,
Don't quote
somewhere
me on
short
that.
of that. So I'm gonna try to do it in one pass, same as always. If somebody needs a break, just get our attention, get Clint's attention, get my attention, get their attention. We'll take a quick break. But other than that, I would like to try to finish, because if we can play this on through, then we'll be able to stop right about 5 o'clock.
Your Honor, it's an hour and 27.
Yeah, perfect. So then that lines up with the 5 o'clock dinner bell. All right, so you're good to go.
Your Honor,
Pause it real
stop.
quick. Y'all come up here real quick. Oh, no. So it's just a critical moment. All right, you all, it's just a clerical moment. Give us just a second. Members of the jury, just while they're doing that, the way these depositions work is the depositions are about this long and cover all kinds of stuff that is not relevant to this. And so I give them directions and say, and it looks like I missed something. Actually, I noticed I missed something as soon as we heard it. So it's just a clerical cleaning up of the video. So y'all just give them just a second, because this is something that they give it to me and I send it back and I missed that.
if it was after he was admitted and brought up to the floor.
Okay. Do your medical records that you have indicate where you first treated him?
I can't tell you with confidence that it was one place or another based on the medical records.
All right. And it's your understanding that Mr. Bennett came to Atrium Carolinas Medical Center for symptoms he claimed arose after an accident on July 1st, 2020, right?
That's what he reported to me.
Okay. In your treatment of Mr. Bennett, did you review any medical records that predated his visit to Atrium Carolinas Medical Center?
I would not have.
Okay. Your treatment of Mr. Bennett would have been based upon his subjective complaints, right?
Correct.
Your objective observations of Mr. Bennett at that time you see him, right?
And the physical exam findings, yes, sir.
Okay. And if any MRIs, CAT scans, or X-rays were taken of Mr. Bennett at time, you would review those films, correct?
Correct.
All right. In your treatment of Mr. Bennett at Atrium Carolinas, you would not have reviewed any prior X-rays, MRIs, or CTs, correct?
Correct.
All right. So in other words, your treatment of Mr. Bennett is based upon how you saw Mr. Bennett at that time, correct?
Yes.
All right. Mr. Bennett, obviously, when he came to Atrium and in your treatment of him, he complained of symptoms arising out of an auto accident, right?
Yes.
All right. He didn't provide you any specifics of the auto accident, right?
Not to my knowledge.
Okay. He didn't tell you how the accident happened, right?
No.
He didn't tell you how fast his tractor was going at the time of the accident, did he?
He did not.
He didn't tell you whether there was another vehicle involved in the accident, did he?
Not to my recollection.
Right. He didn't tell you what his body did within the cab of the tractor at the time of this accident, did he?
Not to my recollection.
All right. I know these are rhetorical questions, but you have no experience in accident reconstruction, right?
None.
Okay. You're not a biomechanic expert who provides opinion as to what bodies do in accidents, do you?
Yes. No, sir.
Okay. Your training as a spine orthopedist is to treat symptoms of patients, right?
Yes, sir.
And to provide surgery if their symptoms require such.
Correct.
In reading your medical narrative, you don't provide any opinions as to what type of vehicle forces were involved in the accident, right?
I do not.
All right. In your medical narrative, you do not provide any opinions as to what biomechanical forces were applied to Mr. Bennett, right?
I do not.
All right. In your medical narrative, you're not providing any opinions as to what Mr. Bennett's body did in terms of hitting anything inside the cab, correct?
Correct.
All right. You're not providing any opinions in this case as to what Mr. Bennett's head or neck did in the accident, are you?
No.
If any impacts occurred in the accident involving Mr. Bennett, you don't know what from what direction the impact occurred, right?
Correct.
The only thing you know about the accident is that Mr. Bennett was involved in one, according to Mr. Bennett telling you, correct?
Correct.
In preparation for today's deposition, did you speak with plaintiff's counsel?
Yes.
You saw, as you testified, you saw Mr. Bennett for the first time when he came to Atrium Medical Center on July 7th, 2020. You remember that testimony?
Yes.
You never treated him prior to July 7th, 2020, correct?
Correct.
Other than living in North Carolina, your job and your family, do you have any medical condition that prevents you from attending a trial?
No.
Now, if you were paid accordingly for your time and expenses to attend trial, you could attend trial if properly subpoenaed, right?
If it was required, yes.
This medical narrative that's Exhibit 3, did you type this narrative?
No, I was provided a rough framework by Charles. I went through and corrected numerous things. I took things out, added things in, altered it so that it was accurate.
Do you recall what you took out?
I don't recall specifically what I took out. I know I added and changed a lot about central cord syndrome specifically, talked about the spinal cord, talked about the acute and chronic nature of it, talked about, let's see, there were some other things that were pretty, I remember, I mean, I think, where was it? There was something about chronicity that I remember specifically addressing. Yeah, I think the paragraph where it talks about the word acute means a condition which develops suddenly, often as a consequence of an identifiable injury, as opposed to something chronic which develops gradually over time.
Okay, so in the final copy of your medical narrative, you added paragraph 3 on the first page.
I believe, or altered it, yes.
How did you alter it?
Again, I don't remember exactly what it said, so I don't know exactly what I would have changed in order to alter it, but I know that I altered it to make it resemble and feel correct to me, in my opinion.
Okay, so there were things in the draft medical narrative that you believe were incorrect, right?
I think there are things that, unless you're an orthopedic board certified, fellowship trained spine surgeon, yeah, there were things that needed to be addended, corrected, updated, shifted around in order to accurately reflect the medical conditions. Yes.
All right. Do you recall anything that was completely erroneous that you had to remove?
I don't recall whether there was or wasn't anything completely erroneous.
And how many drafts did you edit?
One.
And that was the acute part? Oh, excuse me, that was just related to changing the acute?
It was not. Again, I changed other things within it. I don't remember specifically or exactly what they were, but I received it, sat down, took the time to make sure that it was right, read it, reread it, altered it, and sent back one copy. There was not an exchange back and forth.
And you didn't charge for the drafting of this narrative, right?
I don't believe so, no.
All right. How many hours did you spend editing the narrative?
Probably somewhere between 1 and 2.
And you don't plan to bill for the time spent on the narrative?
I don't.
Prior to signing this narrative that's up on our screen, you didn't review any other medical records of Mr. Bennett other than those that you generated in your practice, correct?
Correct. Between the medical records that were started on July 1st that involved July 7th that involved taking care of him.
Okay. So you'd agree with me that these 3 pages of your medical narrative only concern your treatment of Mr. Bennett as you found him on July 7th, 2020,
Yes.
correct?
Yes.
Okay. Let's talk about the narrative in particular. Let's focus on this 3rd paragraph on the first page. It's the paragraph that states the word acute means a condition which develops suddenly, often as a consequence of an identifiable injury, as opposed to something chronic which develops gradually over time. I didn't misstate that, correct?
No, you did not.
And in the paragraph prior to it, you stated that Mr. Bennett was admitted to Atrium for multiple acute disc herniations and central cord syndrome. I read that correct,
Correct.
right? All right. Now, in terms of the acute disc herniations and central cord syndrome, that's only your diagnosis as you found Mr. Bennett on July 7th, 2020, correct?
Correct.
All right. You're offering no opinion as to his condition prior to July 7, 2020, correct?
Correct.
And you're offering no opinions as to his condition prior to July 1, 2020, correct?
Correct.
Now, in terms of the word acute that you used in the third paragraph, you're only describing that in terms of the quick onset of symptoms, correct?
Yes.
Okay. And your use of the word acute in this third paragraph, that does not necessarily mean that it was absolutely caused by the accident of July 1, 2020, correct?
I mean, to my knowledge, he wasn't experiencing, again, this is based on his report, these symptoms prior to his accident.
Okay. And in terms of your diagnosis, you're relying upon Mr. Bennett telling you his symptoms, correct?
It's putting together his symptoms with his imaging studies, and then, yes,
Okay. But in terms of what he's feeling as a human being, you're relying upon Mr. Bennett to tell you how he's feeling, correct?
yes,
You're relying upon Mr. Bennett to tell you the truth, correct?
yes,
You're relying upon Mr. Bennett to tell you his health history to the extent that may impact your treatment, correct?
yes,
All right. If Mr. Bennett had experienced these symptoms well before July 1st, 2020, you would have wanted Mr. Bennett to tell you that, right?
yes,
All right. Because the honesty of the patient is helpful in how you treat the patient, correct?
correct.
I'd like you to focus on the fifth paragraph here on the first page, which begins when I first examined Mr. Bennett. Do you see that paragraph?
Yes,
All right, you state in your medical narrative, when I first examined Mr. Bennett, he was experiencing abnormal numbness and tingling in his left arm. Did I read that correctly?
you did.
Okay, when you wrote he was experiencing abnormal numbness and tingling in his left arm, that's based upon the complaints of Mr. Bennett himself, correct?
That is on a
Okay.
6-year exam, comparing his left side to his right side to what feels normal. Yes,
Okay. And you're relying upon the honesty of Mr. Bennett to tell you that he's experiencing abnormal numbness and tingling in his left arm, right?
correct.
Okay. And in terms of this medical narrative, and you would agree with me, you don't have any prior medical records of Mr. Bennett to help you determine if he was experiencing numbness or tingling before, right?
Correct.
All right. And then you state both arms were abnormally weak as well. Do you see that?
I do.
And again, you're basing the abnormally weak based upon Mr. Bennett telling you that they're abnormally weak, correct?
No, that's based upon a motor exam that's objective, so testing and evaluating his strength.
Okay, but that's a
Physical
test.
exam findings.
Yes, that's testing that you're doing on the spot with Mr. Bennett, right?
Correct.
You're not comparing that testing with any prior medical records of Mr. Bennett.
Correct.
Okay. And then the next sentence, Mr. Bennett also had bladder dysfunction and urine retention. You would agree with me that your narrative does not state what tests were administered to confirm bladder dysfunction and urine retention.
It does not state that.
Okay. So would you agree with me that this bladder dysfunction and urine retention is based upon complaints of Mr. Bennett?
Yes.
All right. At the time you treated him?
Yes.
Okay. The next sentence, a cervical MRI showed that Mr. Bennett had numerous acute disc herniations and there was visible impingement of Mr. Bennett's spinal cord, which resulted in central cord syndrome and myelomalacia. Did I pronounce that last word correctly?
You did. You got it.
Great, perfect. I practiced that all afternoon. And I read that last sentence correct, right?
You did.
All right, in terms of this MRI image, that's based upon the MRI that was conducted while Mr. Bennett was at Atrium, right?
To the best of my recollection, yes.
Okay, you would agree with me that your medical narrative does not cite to any other imaging prior to July 1, 2020. You
Correct.
agree with that, right?
Yes.
Okay, so your medical narrative is not comparing the MRI at Atrium to any other prior medical records, right?
Correct.
All right, so the imaging, as you saw it, was based upon how Mr. Bennett presented to you when he came to the emergency room and was later admitted on July 7th, 2020.
Correct.
All right. Now, to determine if a disc herniation is acute, you have to base that on the patient describing the symptoms and how they occurred, correct?
Correct.
You have to assume that the patient is telling you the truth, that those symptoms happened after a date certain, correct?
Correct.
All right. Now, the way that you could determine is if it's an acute disc herniation is also to determine if, the way, let me strike that. Also, another way to determine if a disc herniation is acute is to compare it with a prior MRI, correct?
Yes.
Okay. And in terms of whether there was visible impingement, to determine if that visible impingement of the spinal cord occurred as a result of an accident, it would be better to just see if there was a prior MRI showing impingement of the spinal cord, right?
Yes.
Now, in terms of the MRI, it's impossible for an MRI to say when a disc herniation occurred just based upon the MRI, right?
Correct.
Also, this is a rhetorical question. Showing visible impingement of the spinal cord on an MRI, that image doesn't show when the impingement occurred, correct?
Correct.
All right.
We need to take a very quick break, you all. So if you all would mind following all the directions I've always given you before, stepping out to the restroom, knocking as soon as you're ready, and then we just need a quick minute. everybody's seated. Again, you all, we're right in the middle of the testimony with Dr. Chapman. You may resume the playing of the video, the deposition, excuse me.
Let's turn to paragraph 6. On page 1. In central cord syndrome occurs when the spinal cord is. Do you see that paragraph?
I do.
All right, and you state in there, you state central cord syndrome affects men more than women and is most commonly suffered by patients aged 50. Did I read that correctly?
Yes, you did.
All right, central cord syndrome most often occurs in people with existing age-related degenerative changes to their neck, correct?
Correct.
When someone has age-related degeneration, the canal through which the spinal cord travel can narrow over time as the discs crowd into the canal, so that if the neck is forcefully extended by the head tilting back, such as in a motor vehicle accident, these tissues can be compressed. Did I read that correctly?
You did.
Okay, so is it fair to say for central cord syndrome to manifest itself, the head and neck of an individual has to be forcefully extended backwards, correct?
No, central cord syndrome really can happen with non-forceful injuries. I mean, even there's examples of patients going to the dentist and developing central cord syndrome from extension of the head and neck.
Okay, when you say the extension of the head and neck, that's tilting backwards, correct?
It is.
Okay, that's your chin lifting up from your chest, correct?
It tends to be, yes.
Okay, and you would agree with me, typically a head extending backwards or the head tilting back in an accident would most likely occur in rear-ending accidents, correct? Did you understand my question, Dr. Chapman?
I did, and my answer was going to be that, as you clearly delineated, I'm not someone who's a specialist in recreating accidents. So I don't know exactly how. I mean, whiplash doesn't happen only when you get hit from the back. So, again, I'm treating patients, not trying to figure out how exactly they got hurt. I'm treating their symptoms and what they present with.
That's fair, but you would agree with me, a patient does not get central cord syndrome when their head tilts forward, correct?
I would not agree definitively that it could not ever occur. No, I would not agree with that. I think it can. Again, my narrative states, it's more likely to be related to extension, but it can occur with flexion. And I understand the example I gave was an extension-based example.
Okay, but you would agree with me, your medical narratives makes no statement about the possibility of central cord syndrome with the head moving forward, right?
I would agree with that.
Okay, and your medical narrative does not state anywhere that there's a possibility for central cord syndrome if the head moves to the side.
It does not state that.
All right, and then it merely states in this paragraph 6 that central cord syndrome occurs if the neck is forcefully extended by the head tilting back.
It does say that.
And the last of paragraph 6, central cord syndrome can happen with very little trauma, correct?
Correct.
And as you said, for an example, someone just leaning back in a dental chair with their head tilting back could cause central cord syndrome.
Correct.
As you sit here today, is it fair to say you're not aware of any evidence indicating that Mr. Bennett's head snapped backwards in the accident in this lawsuit?
Correct.
Let's go to page 2. All right, I'd like you to focus page 2 on your second paragraph that begins according to his medical history. Do you see that paragraph?
Yes.
All right. If I understand your testimony earlier, when you state medical history, you're based upon what Mr. Bennett told you during his treatment at Atrium, correct?
Yes, that's his reported history.
Okay, and again, you would rely upon the truthfulness of his statements with respect to his medical history in terms of treating him, right?
Yes.
Okay, and in writing this medical narrative, you did not rely on any medical records of Mr. Bennett that predated July 1, 2020, right?
Correct.
All right. So it's paragraph second, in the second paragraph of page 2, your narrative said Mr. Bennett did not have any neck issues prior to his truck hitting the guardrail 6 days earlier. That statement is based upon Mr. Bennett's statements to you, correct?
Yes,
And then immediately following his truck wreck, Mr. Bennett did not experience any symptoms. Again, Mr. Bennett's experience of symptoms are based upon Mr. Bennett telling you what his symptoms were, correct?
yes,
Right. You don't have any information as you sit here today whether Mr. Bennett complained of any symptoms prior to July 1, 2020, correct?
not that I'm aware of.
You're not aware of any medical records of Mr. Bennett that predate July 2020, where he's complained of back and neck pain before, right?
No,
This next part, however, several hours following the impact, Mr. Bennett started having neck pain. Again, that is based upon Mr. Bennett describing to you when he started having neck pain, correct?
it is, as is the remainder of that paragraph.
As is the remainder of the paragraph, like you said, correct?
Yes,
Okay, so paragraph 2 of page 2 is based upon Mr. Bennett's description of his symptoms to you at the time you treated him, correct?
correct.
All right, there's no mention in your medical narrative of you reviewing any medical records that predated July 1, 2020, correct?
Correct.
And if Mr. Bennett had any symptoms that predated July 1, 2020, you would have liked to know those symptoms in your treatment of Mr. Bennett, correct?
Yes,
All right, in your third paragraph on the second page, that begins, Mr. Bennett's symptomology is consistent with what is known as secondary spinal cord injury. Did you see that?
yes,
All right. The sentence I want you to focus on is the last sentence of paragraph 3. It begins, in addition, the initial injury to the spinal cord can continue to worsen days and weeks after the initial impact, causing the type of symptomology that Mr. Bennett describes. Did I read that correctly? Again, what Mr. Bennett describes, you rely upon the truthfulness of Mr. Bennett, correct?
yes,
All right. And you said that the spinal cord symptoms can continue to worsen days and weeks after the initial impact. Based upon that statement, it's possible that Mr. Bennett could have had symptoms that predated July 1, 2020. Is that correct?
it is possible, yes.
All right. Or you would agree with me that Mr. Bennett, after the accident, could have suffered some accident that caused his head to extend backwards, causing these symptoms to occur after the accident, correct?
He could have, yes.
All right. And as you testified earlier, such daily living activities as leaning back into a chair for your dental visit could cause central cord syndrome symptoms to arise, correct?
Yeah, those are rare, but they can happen, yes.
I'm going to ask you to focus on paragraph 5 here. In paragraph 5, you start out, in my experience with similar cases, the injuries suffered by Mr. Bennett are not necessarily accompanied by a major trauma. Did I read that correctly?
You did,
Okay, and your narrative says, like earlier, a hyperextension of the neck, and that's the neck extending backwards, correctly? Correct?
yes.
Even if not involving a major traumatic event, is in my experience as a surgeon sufficient to cause the conditions from which Mr. Bennett suffered. Did I read that correctly?
You did,
Nowhere in your medical narrative do you say an extension of the neck forward, right?
correct.
Nowhere in your medical narrative, particularly this paragraph, do you mention an extension of the neck to the side. Is that correct?
That is correct.
All right. It is my understanding of the anatomy of the spine is as the neck extends backwards, the discs are pushed onto the spinal cord in the front, correct?
It kind of closes the space down available for the spinal cord.
Okay, but it's the mechanics of the head extending backwards that pushes the disc onto the cord, right?
It can be, yes.
Well, in fact, that's what you said in your medical narrative on page 1. If I can find it, Mr. Bennett and your paragraph 5, Mr. Bennett had numerous acute disc herniations and there was visible impingement of Mr. Bennett's spinal cord. That's
Correct.
the disc herniations impinging the spinal cord, correct?
Correct.
All right. Now, on page 2, let me get back to it. On paragraph 5, where you said a hyperextension of the neck, your narrative does not state what amount of force caused the hyperextension of Mr. Bennett, does it?
It does not.
It's because you're not a biomechanic, right?
Correct.
Your narrative also does not state that the accident caused a hyperextension of Mr. Bennett's head and neck, correct?
It does not.
All right, you'd agree that accident reconstructionists are the most appropriate for determining what forces are at play in an accident such as this, right? Do you understand my question, Dr. Chapman?
I do. I don't know that's beyond my scope of what would be the most appropriate, accurate way to do that.
And what exactly Mr. Bennett's body did in the cab of his truck at the time of the accident, that would be better determined by different experts, right?
Objection argument.
You're not the type of person to determine what Mr. Bennett's body did inside the cab of his truck at the time of the accident, right?
Correct.
All right, on the second page, paragraph 6. Give me a second.
As I say, I think you're on page 3.
Yeah. All right. I think I made a note here wrong. Okay. Paragraph 6 on page 2, beginning from reviewing Mr. Bennett's history and symptomology. Do you see that?
I do.
Okay. You make the statement in your narrative that Mr. Bennett suffered central cord syndrome, acute disc herniations from C3, C7, and secondary spinal cord myelomalacia resulting from his impact with the guardrail on July 1st, 2020. Did I read that correctly?
You did.
All right. What information do you have from the medical records that Mr. Bennett collided with the guardrail?
I don't recall right now if it's specifically noted in any of the medical records.
Okay. And that would have been based upon Mr. Bennett telling you, right?
It would have been.
Okay. Those medical records indicating that he impacted with a guardrail, that would have been the statements of Mr. Bennett, correct?
Correct.
Okay. And if he impacted any other vehicle prior to impacting the guardrail, that most likely would have been in the medical records as well.
Depending on what he said, yes.
Okay. And in terms of the accident and how it's described for your medical narrative, as you understood, he only made contact with the guardrail, right?
I believe that's what the medical record states.
Okay. And again, describing how the accident occurred would rely upon Mr. Bennett being truthful to you, correct?
Yes.
Now, you state that in your medical narrative, that you believe Mr. Bennett suffered central cord syndrome and acute disc herniations from an impact with the guardrail on July 1st, 2020, right?
Yes.
Would it be important to your diagnosis to know what Mr. Bennett's head did within the accident?
No.
No. Any movement of the head in the accident would support your opinion that the central cord syndrome was caused by the accident.
Again, it's a constellation of the symptoms matching up with the MRI and the physical exam findings that are what define central cord syndrome.
And the description of the accident and the symptoms by Mr. Bennett, correct?
Not the description of the accident, the description of the symptoms. Yes.
Okay. But as your medical narrative state, the accident will require an extension of the head backwards, right?
Again, it doesn't state that it requires that. It says that is the most common cause of central cord syndrome. It doesn't require that, as I stated earlier.
But it does in your medical narrative, it did not describe other possibilities for central cord stenosis syndrome, right?
Correct. It did not. However, on page 1, 2, 3, 4, 5, 6, the paragraph, page 1, paragraph 6, it says central cord syndrome affects men more often than women and is most commonly suffered by. So none of that is specific. None of that is exclusive of any of these other things. Patients younger than 50 can get it. Patients that are female can get it. So it isn't, I was not intending or trying to be specific in terms of stating that it's only hyperextension exercise, only hyperextension that can cause it.
But you did say a hyperextension injury, right?
I did note, yes, hyperextension. I did put hyperextension in the narrative because that is most common, yes.
Okay. But your medical narrative didn't say that central cord syndrome could be caused by any head movement, correct?
Correct. It did not say that.
You specifically said hyperextension injury, correct?
Correct.
All right. And based upon the images you took, Mr. Bennett's subjective and objective complaints, you performed a partial laminectomy at C3 and C7, right?
Yes.
You also performed a laminoplasty.
Yes.
All right. And as indicated by the final paragraphs on page 3, you put Mr. Bennett's neck through a gentle range of motion, correct?
Yes.
All right. And then you indicated in your narrative that there were no issues, correct?
Yes.
All right. As far as your surgery was concerned, the surgery stabilized Mr. Bennett's neck, correct?
His neck wasn't unstable, but yes, it decompressed his spinal canal.
All right. And should have reduced the chance for future central cord syndrome, correct?
Yes.
And Mr. Bennett did not have any complications from his surgery, correct?
Not that I'm aware of.
All right. And post-surgery, you tested him for intact motor function of his arms and legs, correct?
Correct.
He passed, right?
Yes.
And then you discharged him on July 13th, 2020, correct?
Yes.
All right. If you had any concerns about the success of the surgery, you would not have discharged him, right?
No. We would have done other imaging studies or other things if we were concerned about something being progressive or worsening.
And you didn't conduct any of those imaging studies, correct?
We did not.
Okay. Let me pull down Exhibit 3. If you could pull up your medical records of Mr. Bennett, I'll represent to you. It was 11 pages worth that was provided to us by your counsel.
It's in the atrium or for the atrium system, right?
I don't know where it came from. I'll put it up on the screen.
Okay. That'd be great.
I'm going to show you what I've marked as Exhibit 4, which are purportedly your medical records of Ortho Carolina. That's your practice group, correct?
It is.
Okay. These 11 pages were provided to us by your counsel, and I'd like to go through them with you. I have up on the screen page 10 of the medical records of Mr. Bennett at Ortho Carolina. First note here is dated 7/9/2020. Do you see that?
I do.
Okay, you'd agree with me, that's the date of Mr. Bennett's surgery, correct?
Yes.
Okay,
I believe I operated on him July the 8th, 2020.
okay. I'm just going based upon the date
On the
of,
top of the page, yeah.
of your note. Says electronically
Yeah.
signed by Dr. Chapman, 7/9/2020.
Yeah, sometimes there's a brief operative note that's done the day of surgery and the full operative note may not get done until the next day and formally signed.
Okay, but what's up on the screen now dated 7/9/2020 is the formal operative note.
Yes.
Okay. As I go to the next page, it's dated 7/9/2020. It's continued from the prior page. Do you see that?
Yes.
Okay. I have here highlighted in the note, he denies any incontinence or coordination difficulty. That's the comment from Mr. Bennett, correct?
I mean, that's a tagline that's in most of the things, but yes.
Okay. You agree with me that your medical narrative said that you determined he had difficulty with his bladder and incontinence. Do you recall that testimony?
I do.
Okay, but this note is 7/9/2020 indicates he denies any incontinence, correct?
Correct.
I'd like to go to the next note. Looks like he had a follow-up visit with you on July 21st, 2020. You wouldn't have any reason to disagree with my interpretation of this note, right?
I cannot remember the exact date of his follow-up visit with us in clinic.
Okay. Well, as we go through this, correct me if I'm wrong, this looks to be a follow-up visit by Mr. Bennett. Does that appear to be what it is?
This is dated July 13th, 2020.
Okay, so this would be a post-operation exam?
Yes.
Okay. And in your exam, which you signed by Dr. Chapman, that's how you sign these notes, right? You electronically sign them, correct?
Correct. Yes.
And you signed this on July 21st, 2020.
Correct.
All right, but in this note, you'd agree with me, it was found that Mr. Bennett has normal range of motion, normal strength, no tenderness, no swelling, no gait. You see that?
Yes.
All right, and that the left upper extremity paresthesis, however, significantly improved from pre-op,
Yes.
correct? All right, still endorsing numbness, is endorsing a term of art?
No, endorsing is confirming that when asked, he has numbness.
Okay, all right. But otherwise, he's experiencing normal range of motion and normal strength in his arms and extremities?
Yes.
Gotcha. And this looks to be a signed note discharging him on July 14th, 2020, correct?
Yes.
All right, and it was, I guess, dated July 21st, 2020, right?
Correct. Looks like that. Yes.
And then if we scroll down, there's a discharge plan upon him being discharged, correct?
Correct.
And then I guess it's all part of the signed notes by you and Dr. Bullock, correct?
Correct.
All right. There's a note of July 22nd, 2020. Do you know what this note would be for?
I think that's his first and only post-operative follow-up visit in our clinic with Shannon Riley, who's the PA that I worked with.
Okay. So this document, it appears as I'm scrolling up, as it goes chronologically from the most recent on the first page backwards. Would you agree with that?
This note is following the stuff that we just looked at, including the discharge summary. Yes.
Okay. Okay. It looks like on page 4 of Exhibit 4, dated at 7/22, and Shannon Riley, PACE. It says, Mr. Bennett is a 52-year-old male, presents today for a post-op visit. Does that sound accurate?
It does.
So Mr. Bennett, it came back to your practice for post-op evaluation and observation, correct?
Correct.
And then in terms of and it doesn't provide any plan within terms of Mr. Bennett as of this visit on July 22nd, 2020.
So if you scroll back up a little bit higher to the page before that, scroll up just a little bit more, it says
There
right
is the plan.
specifically describes the plan. Yes.
Okay. And the plan from Mr. Bennett, according to your treatment, was that Mr. Bennett will increase activities in a stepwise fashion, continuing to limit bending, lifting, twisting. Is that correct?
Yes.
All right. To this end, he's been given a prescription of formal physical therapy to work on balance, cervical range of motion, and strengthening. You prescribed that for Mr. Bennett, right?
Shannon Riley did. Yes.
Okay, but and you agree with Shannon Riley, correct?
Yes.
All right, and in terms of post-operation for the surgery of the type that Mr. Bennett had, you would want him to go through physical therapy, correct?
Yes.
All right, to work on his balance, correct?
Yes. His range of motion and strengthening.
Right, and you would expect that the patient follow through on that physical therapy, correct?
That would be ideal for their outcome. We like to believe.
All right, and if a patient doesn't do physical therapy, despite being told to do it, they can suffer complications, correct?
They could.
Okay, they could also revert to prior complaints, correct?
They could. Yes.
And you would have expected that Mr. Bennett to follow through on his physical therapy, correct?
Yes.
Do you have any record indicating whether Mr. Bennett attended physical therapy?
I don't believe that I do.
Okay, and your medical narrative did not state that Mr. Bennett attended physical therapy, correct?
I'm unaware if he did. Correct.
Okay. All right, I'd like to scroll up to pages 2 and 3 of Exhibit 4. Do you happen to know what date this document was completed or what visit it's related to?
This looks like our previous intake form that typically would have been completed it would have been completed before his initial follow-up visit.
Okay.
So we wouldn't have had any reason to send it to him prior to him entering our care, and we wouldn't have sent it to him while he was in the hospital.
Gotcha. So this form or the information contained in this form would have been provided by Mr. Bennett, correct?
Yes.
I note on page 3, reason for visit, follow-up after surgery. It says page 3 down here at the bottom, so I assume it's related to prior pages, page 1, 2, and page 1. This would have been information provided by Mr. Bennett, correct?
Correct.
All right, his symptoms, he indicates, the reason he was being treated by you indicates that he's feeling better, correct?
Correct.
All right, and this was obviously post-surgery because it's under follow-up after surgery, correct?
Yes.
All right. Nevertheless, he complains of sharp, throbbing, aching pain, correct?
Correct.
Now, on August 7th, you had a telephone call with Mr. Scholl, correct?
I don't remember if I specifically had a telephone call on August the 7th. That was an incoming telephone call that's that's a triage note. That's an encounter.
Okay, and never, in any event, it's a note that was signed by Annie Sally, correct?
Correct.
Annie Sally, is she one of your nurses there?
To be honest, embarrassingly can't tell you exactly who she is within our organization.
Okay, but probably someone with a fresh face at the front of the practice to welcome patients, correct?
That or in our telephone room. Yes.
Okay. All right, and on August 10th, 2020, here's a note, a therapy progress note. The patient did not show for his scheduled therapy appointment today. You see that?
I do.
Okay, so this would indicate that the prescribed physical therapy, Mr. Bennett did not attend, correct?
Correct.
Okay. All right. Unless Mr. Scholl says anything else that reminds me to ask a question, I've got no further questions.
Good evening, Dr. Chapman. I know we talked on the phone, but let me introduce myself again. My name is Charles Scholl, and I represent Lewis Bennett in this case. I'm going to ask you some questions about your treatment of Lewis. First of all, to save time, I was hoping, and I hate to do this to you, but could you just read your narrative? That covers a lot of what I'm going to talk about. So could you just read the narrative itself, please? Can you pull that up for him?
You want me to read the narrative in its entirety?
Yes, sir.
And Dr. Chapman, this court reporter, can you please just be mindful of the speed you're reading so you don't outpace me? So just kind of read a little bit slower than normal.
Yes. You read my mind. I am Dr. Todd M. Chapman. I'm a board certified orthopedic surgeon specializing in spine surgery. I've practiced spinal orthopedic surgery since September 15th in Charlotte, North Carolina. I have a bachelor's of science degree in biology from Davidson College and a master's of science degree in physiology from Georgetown University. My medical training and medical degree are from Wake Forest University School of Medicine. I completed my orthopedic spinal residency at Duke University Medical Center. I completed an adult and pediatric spine surgery fellowship at the Washington University School of Medicine. I'm licensed to practice in the states of North Carolina and South Carolina. I'm currently an orthopedic surgeon with Ortho Carolina Spine Center and have privileges at numerous area hospitals, including Atrium Carolinas Medical Center. It was at Atrium Medical Center ER that Mr. Lewis Bennett became my patient on July 7th, 2020. Mr. Bennett was admitted to Atrium Health Carolinas Medical Center from its emergency room on July 7th, 2020 for multiple acute disc herniations and central cord syndrome. The word acute means a condition which develops suddenly, often as a consequence of an identifiable injury, as opposed to something chronic which develops gradually over time. A spinal disc is a rubbery cushion with a soft jelly-like center which sits between the vertebrae. A spinal disc acts as a shock absorber to prevent the vertebrae from rubbing together and to provide flexibility and movement. When a herniation occurs, some of the soft jelly-like center squishes out through the tougher rubbery exterior of the disc, similar to the filling being squeezed out of a jelly donut. The herniated portion of the disc can touch or press on the spinal cord, causing pain, neurological issues, and dysfunction of major body systems. When I first examined Mr. Bennett, he was experiencing abnormal numbness and tingling in his left arm. Both arms were abnormally weak as well. Mr. Bennett also had bladder dysfunction and urine retention. A cervical MRI image showed that Mr. Bennett had numerous acute disc herniations, C3 to C7, and there were visible impingement of Mr. Bennett's spinal cord, which resulted in central cord syndrome and myelomalacia. Central cord syndrome occurs when the spinal cord is compressed by the spinal discs or other associated structures. The symptoms described by Mr. Bennett were very consistent with central cord syndrome. Central cord syndrome affects men more often than women and is most commonly suffered by patients aged 50 and older who have sustained a neck cervical hyperextension injury in which the head has tilted backwards. Central cord syndrome most often occurs in people with existing age-related degenerative changes to their neck. When someone has age-related degeneration, the spinal canal through which the spinal cord travels can narrow over time as the discs crowd into the canal, so that if the neck is forcibly extended by the head tilting back, such as in a motor vehicle accident, these tissues can be compressed. There's usually no obvious break or fracture in the bones of the neck, and the spine may be stable. Central cord syndrome can happen with very little trauma. When the spinal cord is compressed, bruising, bleeding, and swelling can occur, particularly in the center or central portions of the spinal cord due to the organization of the spinal cord tracts. The arms are affected more than the legs in this situation. As a result, patients with central cord syndrome tend to be weaker in the arms than in the legs. Many patients with central cord syndrome may be able to walk, but cannot effectively use their arms and hands. According to his medical history, Mr. Bennett did not have any neck issues prior to his truck hitting the guardrail 6 days earlier. Immediately following his truck wreck, Mr. Bennett did not experience any symptoms. However, several hours after the impact, Mr. Bennett started having neck pain. Over the following 5 to 6 days, Mr. Bennett's neck pain and neurological symptoms got worse and worse until they presented to the ER on July 7th. In his initial physical exam at the ER, Mr. Bennett had diminished range of motion with his cervical spine, diminished touch and pinprick in his left upper extremities, and diminished grip, bicep, and tricep strength in those areas. Mr. Bennett's symptomatology is consistent with what is known as a secondary spinal cord injury. A secondary spinal cord injury occurs when an initial trauma causes compression of or initial injury to the spinal cord. As those issues continue to swell, they can further damage the fragile spinal cord over days and weeks and can cause irreparable damage. In addition, the initial injury to the spinal cord can continue to worsen days and weeks after the initial impact, causing the type of symptomatology that Mr. Bennett describes. Diagnostic imaging revealed that Mr. Bennett's spinal cord had myelomalacia, swelling, or edema within the spinal cord. Myelomalacia affects the neurological functions in the spinal cord. Once the spinal injury has occurred, swelling or damage to the blood flow can result in reduced circulation of blood to the area damaged, resulting in further damage to the spinal cord. There's no known treatment to reverse nerve damage due to myelomalacia. Surgery to the area injured may slow or stop further damage, but it cannot repair damage already done. In my experience with similar cases, the injuries suffered by Mr. Bennett are not necessarily accompanied by a major trauma. A hyperextension of the neck, even if not involving a major traumatic event, is, in my experience as a surgeon, sufficient to cause the conditions from which Mr. Bennett suffered. From reviewing Mr. Bennett's history and symptomatology, examining him, looking at his imaging studies, and operating on his neck, I believe to a reasonable degree of medical probability that Mr. Bennett suffered central cord syndrome, acute disc herniations from C3 to C7, and secondary spinal cord myelomalacia resulting from his impact with the guardrail on July 1st, 2020. The delayed onset of Mr. Bennett's symptoms followed by a pronounced worsening of his symptoms over several days does not affect my position on causation. As a result of these conditions, I performed a partial laminectomy at C3 and C7 and a laminoplasty from cervical 4 through cervical 6. July 8th, 2020, a partial laminectomy is a surgical procedure for spinal decompression in which the bony canals through which the spinal cord and nerves pass is opened surgically to create more space for the cord and the nerves to move more freely. The surgery is performed through an incision in the back posterior muscles on the lamina. The lamina bone forms the backside of the spinal canal and makes a roof over the spinal cord. The lamina and thickened ligament overlying the spinal cord are removed, giving the spinal cord and nerves more room. A laminoplasty is also a surgical procedure for spinal decompression. A section of the lamina bone, which forms a rigid roof over the spinal canal, is propped so that the roof opens a little. During a laminoplasty, a hinge is created on one side of the lamina and on the other side is wedged open with metal hardware to bridge the gap in the open section of the spine, thus creating more room in the spinal canal. Upon completion of the laminectomy and laminoplasty, Mr. Bennett's neck was put through a gentle range of motion, which showed that there was no bony impingement. He had intact motor function throughout his arms and legs. Mr. Bennett was discharged from the hospital on July 13th, 2020. I give the above opinions to a reasonable degree of medical certainty this 15th day of September 2023, and then I signed it.
Thank you, Doctor. Doctor, it reads in your medical records that an MRI, quote, an MRI revealed multiple acute disc herniations along with visible cord signal changes resulting in acute cord syndrome. What does a visible cord signal change mean?
That's the myelomalacia. That's where within the spinal cord, which on a T2 weighted MRI image shows what appears to be white fluid within the darkened spinal cord.
Okay. Did Lewis's multiple disc herniations cause significant damage to his spinal cord?
I don't have an ability to ascertain if it was one or another or what specifically was. I know that there was myelomalacia present, I believe, at the C3-4 level.
Okay. Do you recall in his MRI that it read that he had edema, contusion, a cord edema and a contusion on his spinal cord? You remember that?
Yes.
What is cord edema?
Port edema it shows up again as something white. It's part of myelomalacia on a T2 weighted MRI sequence. And it's essentially a result of the injury to the spinal cord, a lot like if you get bumped in the arm or the leg. Your body, it's part of the healing process, draws fluid and inflammatory processes into it to try and heal and repair the area.
Okay, and what is a contusion, doctor?
Yeah, contusion is a bruise.
Okay, so you had a bruised spinal cord?
Roughly, yes.
Okay. Doctor, do all spinal cord injuries for any patient result in immediate paralysis?
No.
Can you describe the difference generally between a spinal cord injury that can cause immediate paralysis and a cord injury where the paralysis could occur over a period of time, please?
Yeah, so an acute spinal cord injury that causes acute paralysis is typically something that happens once. It's an impact to the spinal cord. It typically involves, it can be higher energy, can be lower energy, but it can definitely be higher injury. I think it's more likely associated with higher energy injuries. And it's a more resultant, more significant physical deformation or change to the spinal cord itself, as opposed to incomplete injuries, which are where the paralysis doesn't occur. It's not complete. It can happen in a delayed fashion where there's an insult and then there's this kind of secondary swelling within the spinal cord. And the spinal canal is it has a fixed diameter, has a fixed area. And as the swelling occurs, that can put compression on the spinal cord itself.
Okay. And did Lewis report that his spinal cord injury or his paralysis got worse over a period of 6 days before he came to see you?
Yeah, he stated that originally after the injury, he didn't have the symptoms that he was experiencing when he presented.
Okay. And at our request, did an animation technician hired by our firm reach out to you for guidance on how you think Lewis's spinal cord may have progressed over the 6 days in question?
Yes.
I'd like to show you this animation. Could you play Exhibit 3, please?
Yes, give me 1 second.
All right, doctor, my next question is, in your opinion, based on Lewis's history that he gave you your examination, your treatment of Lewis, does the animation accurately show the progression of Lewis's spinal cord damage from the date of the accident until the date of his first MRI showing the spinal cord damage that you saw?
So I don't have any way to know what his MRI looked like before the injury, so I don't have any way to determine it. But I know that at the date of his MRI, I know what it looked like, which was the last little snippet, the actual picture of his MRI in that video. In terms of progression, yes, I mean, that is a plausible way of progression.
Okay. And you testified earlier that a acute central cord syndrome like Mr. Bennett suffered from, in this case, can result from a fairly minor trauma or impact?
Yes.
Do you have any information on any other trauma that Lewis might have suffered besides the truck wreck that he talked to you about?
Not specifically since his accident, no.
No, I mean before or from the time he came in and saw you and you treated, did you have any information on any type of other trauma he might have suffered besides the truck wreck that he talked to you about?
No.
If Mr. Bennett testified that his head, let me ask you this first. You testified that an extension or a flexion could cause central cord syndrome. Could a side-to-side neck movement also cause central cord syndrome? You can answer, please.
So again, I think any direction of neck range of motion can cause it. Extension is the most common cause.
Okay, but a side-to-side could cause it as well.
It could potentially, yes.
And according to your notes, did Lewis report to you that he didn't think that he had any injury originally when the accident occurred?
I don't think he sought treatment for it.
Okay. And in your notes, I don't know if you went over them before, and I made a note of this, but it said that Lewis, quote unquote, endorsed his ability to self-extricate and ambulate on the scene. Do you recall that?
Yeah, do you think I recall that? Yes.
Okay. If there was a video which showed Lewis getting in and out of his truck after police pulled over the defendant, and Lewis was walking around right after the accident with no apparent physical limitations, would that be an issue that would cause you to doubt your opinion that Lewis was injured in the truck accident?
I don't think it would really have any effect. I mean, again, I was treating him several days later,
Okay.
And treating the symptoms and the patient that were in front of me at the time that he presented to Atrium.
Okay. But would the fact that he seemed to be okay, or the fact that he had was able to get in and out of his truck, if you saw a picture of that, would that alarm you in any way regarding your causation opinion in this case?
No, I mean, again, there can be delayed onset of these symptoms. So it's a little bit hard to extrapolate from what that means as to, that would mean that it couldn't have happened at that accident.
All right. Thank you, Doctor. Doctor, I sent you some records that were referred to in your direct examination. One of those was an excerpt from Mr. Bennett's deposition where he talked about his throat being cut in 1999. Do you recall that, reading that in his deposition?
Yes.
Okay. If he had his throat cut in 1999 and it did not implicate any of his spinal structures, would that be at all relevant to his acute spinal cord injury for which you performed the surgery?
Yeah, if it didn't involve any bones or discs, I don't know how it would necessarily be implicated.
Okay. There's also a record from 2013. Do you recall reviewing those?
Are these related to his concussion, I believe?
Yes, sir. In 2013, I think it was a forklift
Yep.
incident. Do you
Yes.
recall reading those?
Yes.
Is based on your review, is that relevant at all, that incident in 2013, relevant at all to a spinal cord injury for which you performed surgery?
No.
Are you aware that the defense hired a doctor in this case to give opinions about Lewis's condition?
No.
Okay. Were you ever contacted by Dr. Frankel about your treatment of Lewis in this case?
No.
Are you aware that the defense hired Mr. Frankel, and Dr. Frankel speculated that Lewis may have become paralyzed by vomiting a few days after this truck wreck?
Objection mischaracterizes Frankel's testimony.
Okay. Are you aware of that, sir?
I'm not.
What would be your opinion about that?
He never reported to me that he vomited, so I would have no, I think that would get, again, any kind of neck range of motion could cause it, but I don't know that vomiting necessarily would be something, and that wasn't something that was reported to me.
Okay. If Lewis's paralysis symptoms began days before he vomited, does it make sense that vomiting caused his central cord syndrome?
If his symptoms started before the vomiting, then no, the vomiting couldn't have caused his symptoms.
Thank you, doctor. Doctor, was your physical examination of Mr. Bennett important for you in making your treatment decisions, including surgery?
Yes.
What kind of things did you find out in your clinical examination of Lewis that someone just reading his records could not know?
I don't know that there's anything necessarily that you wouldn't know from reading the records. I think it identified the weakness of his left upper extremity.
Okay.
But that's documented. So I don't think there's anything like hidden or not reported in the medical records that would have an impact on the decision-making process.
Have you ever operated on a patient without physically examining the patient, except in an emergency situation?
No.
Doctor, you testified about Mr. Bennett's discharge, and you said that, or it's apparent from his records, maybe that he did not attend his physical therapy appointments 2 months or a month after he was discharged from the hospital. Do you recall that?
Yes.
Do you have any knowledge of him following up with another doctor for physical therapy or another medical provider for physical therapy?
I do not.
Okay. Have you even seen him since the date he was discharged from your hospital?
I have not.
Do you know what medical treatment he's gotten and who he may have treated with after you discharged him?
I have not and do not know.
Okay. Now, there was some records that indicated that he had normal range of motion when he was discharged from the hospital. What was Mr. Bennett's, do you recall Mr. Bennett's physical condition when he left the hospital? Was he 100%? Did he have any limitations at all?
I don't recall specifically. No.
Okay.
I think it said normal range of motion, which normal after a surgery is not normal, not having had a surgery.
Okay.
So certainly there's some post-surgical debilitation and limited range of motion from not having surgery. But again, he's had surgery, so his range of motion was normal for his post-operative state.
Okay. Now, someone that has never had any issues with their neck or spine, would they be, I'm sorry, if someone's never had an issue with their neck or spine or any pain or anything, would that person necessarily ever need an MRI unless they had such pain?
No.
Okay. And so if, in terms of comments about MRIs that existed prior to Lewis's admission into the hospital in North Carolina, if he never had any issues with his neck, would there be any reason for a doctor like you to order an MRI of his neck?
No, I don't see asymptomatic patients, and I certainly don't order MRIs on them.
Thank you, doctor. Doctor, was Mr. Bennett a cooperative patient?
To my recollection, yes.
Was he a compliant patient?
I mean, when he was in the hospital, he was. He didn't attend the physical therapy, and he didn't follow back up with me as was recommended by Shannon.
Okay. Did you ever have any reason to doubt Mr. Bennett's description of his condition or his credibility in describing what happened to him?
No.
Were Lewis's descriptions of his symptoms consistent with what you expected to find during his physical examination?
Yeah, they correlated.
Were Lewis, I'm sorry, go ahead.
No, I was just gonna say there's nothing glaringly abnormal or not consistent about it.
Were Lewis's descriptions of his symptoms consistent with what you expected to see when you saw his spinal cord damage in his MRI images and later when you operated on him and viewed his anatomy with your own eyes?
Yes.
Doctor, would it be a substantial hardship for you and your patients if you were subpoenaed to travel from North Carolina to Georgia to testify live at a trial that may last a week or more?
Yeah, I mean,
Okay. Doctor, do you give all your
Actually, not
opinions?
respond.
I'm sorry, can you answer the
yes,
question?
yes, it would be a hardship for me to travel to Georgia and spend a week sitting in a courtroom in Georgia.
Doctor, do you give all your opinions in this case to a reasonable degree of medical probability?
Yes.
That's all I have, doctor. Thank you.
I have follow-up questions. Dr. Chapman, you agree with me that animation that was shown to everybody is of a head flexing backwards, correct?
Correct.
It's called a hyperflexion, correct?
I'd call it hyperextension.
Yeah.
Hyperflexion, flexion would indicate a forward bend, extension is backwards.
Yeah. You recall your testimony earlier that the flexion of the head and neck can be just caused by a minor impact, correct?
I don't know that I specifically testified that flexion can be caused by anything specific or got into the major minor, but yes, any your neck can move in any direction based on any degree or significance of trauma. Yes.
Okay, and you, in your medical narrative, said central cord syndrome can happen with very little trauma, correct?
Correct.
In fact, you testified that central cord syndrome could happen in some cases where someone leaned back into a dental chair, correct?
Correct.
Okay. Violent bout of vomiting, could that cause central cord syndrome with the right underlying degenerative issues?
I mean, I can't tell you that it couldn't. So yes, it theoretically could.
I have no further questions.
Doctor, just one more question. Does the fact that the animation demonstrated a extension mechanism of injury, does that negate the fact that the injury to Lewis could have happened with a side-to-side motion or an extension motion?
It doesn't.
Flexion motion, I'm sorry.
It does not.
Thank you, doctor. That's all I have.
All right. In terms of the bruising you saw in the MRI on the central cord, does that indicate whether it was a hyperflexion or what's the opposite, head going
Extension.
forward?
Yeah, flexion going forward, extension going backward. The specific location does not necessarily, to my knowledge, indicate whether it's a flexion or extension type injury.
All right, but nevertheless, the animation just showed a extension, correct?
That's correct.
Now, Dr. Chapman, do you, give me a second here. Are you familiar with Dr. Bendix?
Not to my knowledge, no.
The orthopedic surgeon who performed surgery on Mr. Bennett after your surgery?
I'm not.
Okay, no further questions.
I don't have anything else. Thank you.
All right, so that brings us to the conclusion of today. I appreciate y'all's patience and your attention as you paid attention today. I don't think we even had to wake anybody up. So good job. This concludes us for today. As we talked about earlier, tomorrow is Juneteenth. And so we will not, so don't come back here. No one's going to be here. Go celebrate with your families. On Friday, the county is officially kind of closed. It's a weird situation where they said the departments could close, but the courthouse is open. And after thinking it through, I realized that any day we don't take is a day we're going to put on to the other side of it. And we figured y'all rather keep going a little bit. So we realized we can do basically a half a day on Friday and get a lot done. So we're going to start at 10. That's because of me. I've got a conflict. So we're starting at 10 o'clock Friday morning. So you all will return here at 9:59 a.m. Friday morning. We will jump in and we believe we'll be able to finish the plaintiff's case in chief hopefully that day on Friday. And then that's kind of where we're at. But obviously these are all fluid. Does anybody have any questions for me where we're at right now?